Sure. Yeah, we will start. Yeah.
Good morning, sir. Maruti, sir.
Sir, admit.
Good morning, madam.
Thank you
How
for
are you?
joining. Yeah, fine, sir. Thank you.
Yeah. It's my pleasure to.
Yes, we will start. With the computer audio. Good morning, distinguished guest participants and esteemed dignitaries. It is with great pleasure we commence today's session of the 2 days international webinar on intricacies of military, artificial intelligence, international humanitarian law through the lens of precautionary principle. We are honored to welcome you to this 2 days webinar organized by JSS Law College in collaboration with the Nairobi Law School, Nairobi University, University of Fertilizer, Brazil, and Institute of Legal and Policy Research. The focus of today's program is on the intersection discussion between the artificial intelligence, military law, and humanitarian aspects. We examine these issues through the lens of precautionary principles, looking into the technology, and we will discuss on the military ethics, and we have experts to discuss and explore in these topics and to highlight on the opportunities and the challenges that we face during the military operations. Today's discussion will address by the paper presenters on the legal implications of AI in warfare and ethical considerations surrounding an autonomous weapon system and how international humanitarian law must evolve to mitigate these risks posed by such technologies. Our aim is to foster to deeper understanding how the precautionary principle can guide and policy and legal frameworks in this rapid advanced field. We thank our esteemed panelists who joined us yesterday. And today we are also grateful to our esteemed dignitaries. We have Professor Dr. Maruti, Professor of International Law, Department of Studies in Law, University of Mysore, and Professor Solomon Dedesi from Ethiopia, and Mr. Raul from Netherlands, who will be speaking first. And it is followed by our lengthy lineup of the outstanding paper presenters. So in this occasion, I would like to request Dr. N. Wanishiri, esteemed principal of JSS Law College, to welcome the guest, and we shall proceed formally with today's program. Ma'am, over to you.
Thank you, Mr. Syed. A very pleasant morning to one and all present, online and offline. It is a great pleasure for me to start the second day of the 2-day international webinar on military artificial intelligence and international humanitarian law through the lens of precautionary principles. So we have heard very good words and thoughts on the day one, which has given food for thought to continue with this day. And as Mr. Syed rightly pointed out, I am bound to invite and welcome Professor Dr. Maruti TR, the speaker of the day, and of course the guest, who is a professor of international law, Department of Studies in Law from the University of Mysore, India, and Professor Solomon Tadase. He's doing a great job. Also was part of the Mada Valabo University. Especially, we were all impressed with his work on the free legal aid services, especially to the women and children. And Mr. Raul Cardillani Lepets, advanced master's in Air and Space Law, International Institute of Air and Space Law, Leiden University, Netherlands. So I deem it a great pleasure to extend my warmest welcome and invite them to the second day together so that we don't take more of time. And of course, I would fail on my part of duty if I don't welcome Professor K. Suresh, the Chief Executive of this college, in his absentia. Mr. Syed, the convener and the coordinator, organizing secretary of the program, Mr. Ashray Chakraborty, the assistant professor in this college, who is here with us, Mr. Madhukumar, the systems analyst, and our student coordinators, Ms. Rajeshwari and Nanda, who are with us here. A very warm welcome once again to one and all, and hearty welcome to this two-day international webinar. Thank you. Over to Syed.
So it is my privilege now to welcome Professor Dr. Maruti to share his perspective and give inaugural address. Before we start, we would like to brief about sir's academic profile. Please, Nanda, highlight about the Professor Maruti.
Thank you, sir. Good morning. It is indeed my privilege that I introduce a luminary in the field of law, a distinct academician and influential administrator, and a dedicated community servant, Professor Maruti. Professor Dr. Maruti TR stands as a towering figure for his profound contribution to the international law and legal academia. Born in Shivamogga district and bred in the culturally rich city of Mysore, his journey into the realms of law starts with a bachelor law from Kuvempu University. Sir pursued his MA and LLM at the University of Mysore. Professor has completed his doctoral thesis and gained his PhD in the year 2007. Sir is currently serving as the Professor of International Law at the Department of Studies in Law at University of Mysore. Professor is a stalwart in shaping legal education and being pioneer of Model United Nations conferences at the University of Mysore. Professor Maruti has lent his expertise to international bodies such as the United Nations Commissioner for Refugees and many more. His unwavering dedication to the pursuit of excellence in legal scholarship and education has earned acclaim both domestically and internationally, cementing his legacy as preeminent authority in law. We are honored to have him with us today as we welcome a visionary, an educator and a beacon of excellence, Professor Maruti.
So the floor is yours. You may proceed with your talk.
Thank you very much. Am I audible?
Yes, sir. You are very much audible.
Yeah. First of all, let me congratulate JSS College for organizing this kind of a wonderful program, especially on artificial intelligence and precautionary principle. In fact, when I received a call from Kudrat, I could give my positive reply to address this issue. Madam Dr. Vanishri, esteemed principal of JSS Law College, Mysore, CEO, Professor Sureshji, President of Institute of Legal and Policy Research, Syed Kudrat, Ashray Chakraborty, academicians, students, research scholars, above ladies and gentlemen. In fact, I have not come here to teach you on international humanitarian law. This has come to my mind to share few words about the synergy between artificial intelligence and the humanitarian law. You know the fact that the moment when you are just dealing with the technology looks as if an eagle flying faster and faster, whereas law looks as if a tortoise moving very slowly. So you have to create a chemistry between these two. Simply, you cannot ignore the way in which the states are actually targeting others at the international level as well. Before I'm going to deal with this, no matter however it could be, technology is one wherein it has given you some inputs to understand uh, the concept of war. As it has been defined by OpenAIM long ago in connection to the concept of war, according to him, war is nothing but contest between states. But in modern days, this definition is redundant. It needs to be clarified and redefined once again. War not only, you know, applicable to states but also individuals. These are the things which shall also been actually looked into when you're just dealing with this subject matter. And you can have a number of issues on challenging uh, perceptions. In a silver linings, can have some questions as well. What do you need to know about the artificial intelligence in armed conflict? What is artificial intelligence? How could artificial intelligence be deployed in armed conflict? And how is artificial intelligence used to inform military decisions? How could artificial intelligence be used in cyber and information warfare? How exactly International Committee of Red Cross has been actually successful in creating the synergy between the technological developments and the international humanitarian law. And you know very well that ICRC was actually initiated on the basis of Henry Dunant approaches. He was a small guy who was actually transacting with many. When he was actually crossing a battle of Salfarino, he saw some sick and wounded. He did not bother about his business. He took them to nearest room, started giving first aid. Soon after that, he sat with his own people and started writing some views about the Battle of Salfarino. The Battle of Salfarino was actually triggered uh, to sit at the international level to understand the concept of the humanity. So what is humanity? Everybody knows. Even in Mahabharata, you can find um, Dharma Yuddha and Adharma Yuddha, just and unjust war, or legal or illegal. This has happened even from the perspective of Indian the war system as well. If you just look into these, in fact, military laws are omnipresent in Mahabharata. The two major violations of rules with most severe consequences concern unfair killing of a hero's son, Arjuna's son Abhimanyu, and of a hero's father, Ashwatthama's father Drona, was also actually deprived of weapon and armor. When Abhimanyu's father Arjuna finds about the adharmic killing of his son, he swears revenge. This has happened in Mahabharata. It is not actually new to us. Everybody knows. This death also becomes the ground for any further rationalization which allow Pandavas to break law of war. Further, they killed weaponless Drona and charitless Karna. So these are the things you may be finding when you are just dealing with the ancient war system as well. If you just look into international humanitarian law, of course, much has been discussed on international humanitarian law. I think nothing is left out to me. However, it stimulates me to share few words about the international humanitarian law because few might have outspoken on the artificial intelligence and the international humanitarian law. International humanitarian law earlier, it had to be called as law of war. That law of war was actually divided into three. It could be aerial warfare, naval warfare, and marine war. I mean, to say land warfare. So based on these three main streams, the law was actually divided into several. This is one thing. On the other hand, if rather I would say, few critics may say that there is no law at all. But I'm a student of law. Still, I'm just reading and writing on international humanitarian law. I can say that we have had as many as legislations, I mean to say international covenants at the international level to address these issues. And you cannot leave the artificial intelligence casually. If the human sufferings are more and more, obviously you have to apply Geneva Convention on Law of War 1949 and Additional Protocol 1977. So these are the major laws we have which are addressing the issues and challenges at the international level as well. Apart from this, if you just look into the rules of war, we have, like just in bello. What is just in bello? Just in bello in the sense that law of armed conflict. These are the two major observations we have when it comes to the knowledge of the international humanitarian law. It could be, just in bello and just ad bellum. Just in bello in the sense that law of armed conflict, just ad bellum means the rules regulating the resort of force. And you cannot use force as far as public international is concerned. And you know the fact that en masse that itself is prohibited. However, there are many instances wherein states can use their force. Force majeure is also applicable in the rarest rare circumstances. Of course, no matter, keeping enough all these issues and challenges, United Nations organization has been effectively functioning with you to overcome scourge of war. That's very important from the point of view of understanding the war crisis. So war is war. You cannot stop war. You cannot stop war. Tomorrow something may be widespread. Perhaps you may have actually experienced, especially the war between America and Iraq, war in Ukraine, war in Chechnya, Georgia, and rest of them. Look into the ongoing crisis like Yemen civil war, Syrian civil war, and the rest of them. And you know the fact that the moment when you are dealing with these, there are two segments should be looked into. Take for example, it could be internal and international armed conflict. As far as the historians are concerned, there was more than 12,751 wars took place on this Earth planet. They include 22 major wars and 6 internal armed conflicts. See, keeping enough all these examples and parameters, of course, no matter, and you cannot say that there is no law at all to address the issues and challenges of artificial intelligence in these days. There has been tremendous changes have occurred in the image of contemporary science and technology. This is very, very important. You have to understand from the point of view of the science and technology. This is what perhaps many scholars may have known on the basis of Stephen Wego's approaches. What he says lies an instrument of social change, which may change from time to time as a science and technological development. So keeping in of these, you cannot ignore the developments that are taken place on the basis of Geneva Conventions and the Additional Protocol 1977. Apart from this, you have a Martin's Class. So Martin's Class and Labor Code. So Martin's Class and Labor Code, they are highly useful with a view to prosecute the people who are responsible for mass killing of people during war situation. Keeping enough this, no matter, especially in the First and Second World War, we couldn't find international criminal law. international criminal law was very meager during First and Second World War. When we were just, interrogating the people, we couldn't find international court at all. We had just trials like Nuremberg trial, Malala trial, Tokyo trial, and German trial. Soon after that, in 1993, International Criminal Tribunal for former Yugoslavia, the International Criminal Tribunal for Rwanda. These were the major, uh, you know, tribunals exposed with you to prosecute the people who are responsible for crimes against humanity, war crimes, genocide, and crimes against peace. Now we have Rome Statute 1998. Under Rome Statute 1998, you can uh, target these people who are responsible for genocide, crimes against humanity, war crimes, and rest of them. So keeping enough all these examples, if rather you would say, and you cannot say that there's no law at all. We have got as many as international covenants which are dealing with these issues and challenges as well. So therefore, I would like to share on the basis of these factors by saying that all states are responsible if they violate the international obligations among the nations. This is what draft articles on state responsibility for internationally wrongful acts have um, come to our mind to understand the state responsibility as such. So, keeping of all these examples, however, you may have had as many as world crisis. These world crises should be called and looked into, and there is a room for discussing all these issues. So I must share with you the moment when you are dealing with artificial intelligence, the issues in connection to artificial intelligence shall not be ignored, and you have to see from the ethical and moral point of view. And this is one thing, and on the other hand, all belligerent states or the combatants are highly responsible um, to pay for it, and the compensation not to be granted. This is what the Rome Statute 1998 has come out with new approaches with you to overcome the war of aggression, or what shall I say, the coercive measures in which the states have been actually using here and there. These are the things that shall also been actually looked into. Apart from this, as you have already been known, the rivalry between the United States and USSR, uh, it's actually remained even today. So keeping in of these, as I have already been cited, that the Martin's class was actually emphasized by USSR, whereas labor code was actually emphasized by United States of America. Keeping in of all these aspects, and one should not be actually forgotten to have a look on the Hague regulations 1899 and 1907, which are highly essential with a view to understand the concept of international humanitarian law. I must say with you, what is international humanitarian law? Humanitarian law is nothing but application of human rights during war situation. In otherwise manner, I can say that human rights plus war is equal to international humanitarian law. So keeping of all these aspects and such a thing, no matter however it could be, we have to explore ourselves with a view to understand the synergy between artificial intelligence and international humanitarian law. They should go hand in hand. Sometimes, of course, military necessity is actually quite demanding during war situation. When there is a military necessity, you shall not be forgotten on the humanity. Military necessity and the humanity should be balanced. This is what we have come across with the concept of the rule of proportionality. So what is rule of proportionality? Rule of proportionality is just, creating the synergy between military necessity and the humanity. That's very important from the point of view of understanding the humanity during war situation. This is one thing. On the other hand, even in absence of a treaty making process, we have had customary law, which is actually well noted under Article 38 paragraph 1 B of the ICJ Charter 1946 is very clear about the application of the customary law during a war situation as well. So, in one of these observations, if rather I would say, though you are not a member of any one of the convention, and you are required to follow the customary law among the nations. So, with these a few aspects, even in absence of many things, there are some soft laws which are exposed by General Assembly and the Security Council recommendations as well. This is one thing. On the other hand, if rather I would say the role of ICRC in this regard is essential. This is what ICRC people have been keep working day and night with a view to restore or um, um, maintain the international peace and security during a war situation as well. So with these few aspects, no matter however it could be, you are required to understand Geneva Conventions, additional protocols, Martin's Class, Labor Code. The role of ICRC shall also be actually called for with you to understand the advanced technology in which you have been using during a war situation as such. You have no moral right to kill people during war situation. This is very important. You can kill combatants, but you cannot kill civilians. Civilians are highly protected under international humanitarian law. So with these few aspects, of course, many scholars may have outspoken on the artificial intelligence. No matter, um, these are my inputs with you to create a synergy between artificial intelligence and the humanitarian law. See, as I've already been very clear in many platforms by saying that we need to have peace. Peace, it does not mean it is an absence of war. Peace means presence of justice. So this is very important. And on the other hand, if rather you would say, this is what Martin's class, which has outspoken on the basis of humanity and a dictate of public conscience. So based on dictate of public conscience, you can overcome some of the issues and challenges in connection to artificial intelligence. With these few aspects, I take this opportunity to thank all of you for giving me an opportunity to share a few words about today's program. Thank you very much and hope for the best. Thank you.
Thank you so much, sir, for your thought-provoking speech. It is my pleasure now to invite Mr. Raul Cardellini Leberts from Netherlands. Before we start with sir's speech, we would like to highlight his academic profile. Please highlight about that. Yes.
A very good morning, sir.
Thank you, Kudrat.
A very good morning, sir. It gives me immense pleasure to introduce you. Ladies and gentlemen, it's a great pleasure to introduce our distinguished guest speaker, Raul Cardellini, an Italian native who has graciously accepted our invitation to share their expertise with us today. Sir is a highly respected, accomplished expert, author, and specialist in the field of law with an impressive years of career marked by numerous achievements and contributions. Their extensive experience spans in international relations, politics, air and space law. Sir has done 5 master degrees, in which he have the first one which he have done in the year 2015 to 2022, the Masters of Law in University of Perugia. In the year 2023, he completed Masters in European Legal Studies in the University of Perugia. And in the year 2023 till October 2023, Sir has completed his Master in Space Institution and Policies in SIOI. In 2023 to 2024, Sir has done his Advanced Master in Air and Space Law. And Sir has also completed his Master in International Relations and Politics in Lamsa University in the year 2024 to 2020, which is continuing and which he graduate in the year 2025. Sir is a very thoughtful leader and an innovator in their field. Throughout their career, Sir has demonstrated remarkable ability in participating research and study and has done his traineeship in the Center for Global Governance and Studies in Leuven, an International Institute for Air and Space Law School at Free University Berlin, and Law School at Free University Berlin. He was a visiting student and he have done his traineeship there. He have also done a traineeship in Catholic University in Leuven. Sir have also actively enrolled in summer and winter school courses and extended his knowledge in space matters, business law, international relations, and penitentiary law and Air Force. Sir have also done and actively participated in non-profit and charity works, and he was a research director in Space Pride, an advisory board director in Prague Model United Nations, a governing body director in KU Leuven Model United Nations, a secretary in Gender Equality Group Space Generation Advisory Council, director of traineeships in European Law Schools Association. Sir have also participated in various academic conferences, and a few of them are Space Habitat event in 2024, the United Nations Conference on Space and Policy, the Conference on the Framework of AI and Autonomous Systems, and Sirius Space Talks in 2024 conference. Sir have done numerous publications and in prestigious seminars and conferences worldwide. And Sir have also simulated various Model United Nations and moot court events. And it is an honor to welcome Mr. Raul Cardellini to our stage. And we look forward from learning from you, sir. A very welcome, sir.
So now it is our pleasure to invite him to discuss on military application of AI in outer space and international humanitarian law perspective. Sir, the floor is yours. You may proceed.
Thank you very much, Trudy, for that incredible introduction. Thank you very much indeed. Good morning, distinguished guests, esteemed colleagues, organizers, and participants from around the world. Firstly, I would like to apologize as I was supposed to be speaking yesterday. Unfortunately, I had some commitments that overlapped with the conference, and so I could not. However, I would like to specifically thank you very much, the organizers, for allowing me to move my talk from yesterday to today. It is a profound honor and privilege to address such a gathering on the intricacies of military AI and international humanitarian law through the lens of precautionary principles. As I've said, I would like to extend my heartfelt gratitude to the University of Nairobi Law School, the International Committee of the Red Cross Nairobi, the University of Fortaleza, Brazil, JSS Law College, Mysore, India, and the Institute of Legal and Policy Research for their collaborative efforts in organizing this remarkable event. Your dedication to fostering dialogue on such a critical and timely topic is truly commendable. Today, I will be addressing, as it was already highlighted, the topic of AI in military operations in the space domain, trying to highlight the issues from an international humanitarian law perspective. So the exploration and utilization of outer space has always held dual character, intertwining peaceful and military purposes. As enshrined in the 1967 Outer Space Treaty and other instruments forming the Corpus Juris Spatialis, meaning the set of laws that govern and control the use and activities of outer space, the governance of space activities is premised on principles intended to promote peace. Yet the history of space technology reveals its deep roots in military ambitions. As far back as before World War II, and specifically during World War II, actually, the use of space was witnessed in warfighting when Germany launched V-2 rockets with ballistic trajectories towards Britain. In more recent times, the first military campaign where the space domain played a crucial role occurred during the First Gulf War of 1990 to 1991. Satellite-enabled GPS, meaning Global Positioning System, provided precision navigation and targeting for kinetic effects and space-based observation of the conflict theater for situational awareness, significantly contributing to success of Operation Desert Storm, for example. Since the end of the Gulf War, of the first Gulf War, militaries have gradually expanded their efforts to leverage the space domain as a way to introduce operational advantages. However, this growing dependency has also created new vulnerabilities for military operations and new issues that opponents are increasingly capable of exploiting. This context highlights the importance of refocusing military attention on planning and developing space capabilities to address emerging threats and strategic vulnerabilities, a need that arises against the backdrop of renewed great power competition that I will not go really into detail in today because it's not the focus of my presentation. Future military operations between peer competitors will be characterized by a multi-domain operations approach, which will feature the integrated and parallel using of air, sea, land, cyberspace, and lastly, also the space domain, which in December 2019, with the London Declaration, was highlighted as one of the NATO operational domains, thus a domain to which also Article 5 of the Washington Treaty will extend to. The military will make use of all operational domains, but particularly the space domain, as it has become vital to modern decision making due to it allowing for very speedy decision making at the command and control levels. So the space domain is the only way to ensure continuous cross-border intelligence and situational awareness today that will facilitate military activities across the board in a multi-domain system. So artificial intelligence and autonomous systems obviously offer an unprecedented amount of capabilities for enhancing space operations. But their use obviously must be scrutinized through the lens of international humanitarian law. International humanitarian law, as highlighted also before, establishes some critical principles: distinction, proportionality, and precautions. And these principles must be adhered to in all our conflict situations and scenarios, including those extending to outer space. These principles require clear accountability and human oversight to ensure that deployment of AI-driven systems align with the legal obligations enshrined in the Corpus Juris Spatialis and in customary international law and general public international law. Artificial intelligence has become integral to intelligence, surveillance, and reconnaissance activities in space, enabling real-time situational awareness and decision-making in the increasingly complex space environment. For instance, space domain awareness, also defined as SDA, involves identifying, characterizing, and understanding factors that could affect space operations directly. And the SDA, space domain awareness, benefits significantly from AI's ability to analyze data and predict threats. However, such activities must be carefully managed to prevent violations of the principles of proportionality, distinction, and precautions, particularly in scenarios involving dual-use objects like satellites, which oftentimes serve both civilian and military purposes. The ability of artificial intelligence to autonomously process and analyze vast amounts of data introduces both opportunities and challenges for IHL compliance. On one hand, this capability allows for rapid decision-making and the identification of emerging threats and patterns, potentially enhancing compliance with the precautionary principle. On the other, however, the inherent complexity and opacity of certain AI systems, especially those using machine learning algorithms, make it difficult to predict their behaviors in dynamic scenarios. And this unpredictability can hinder operators' ability to ensure that attacks comply with the principles of distinction, proportionality, and precautions, increasing the risk of unintended harm. AI-driven decision-making thus represents a particularly transformative application in space operations. By analyzing space source data sets, AI systems can try to predict potential threats and optimize response strategies. And this capability enhances the adaptability in military planning and operations. For example, the US Space Force is utilizing AI to accelerate decision-making cycles and improve strategic planning, while similar efforts are also being undertaken by the Popular Republic of China. sorry, by the People's Republic of China. Sorry, it's 5 a.m. In my time zone. That's why I got confused. Yes, by the People's Republic of China, which is focusing on leveraging artificial intelligence for autonomous threat analysis and operational efficiency. And these developments effectively highlight the pressing need for robust legal and ethical frameworks to effectively try and guide the development of such systems in an ethical way. So while the potential of AI and autonomous systems in military space operations is vast, their uses raises significant challenges under IHL. The autonomy of these systems could effectively impede human operators' ability to make necessary legal judgments, such as determining whether an attack will cause excessive harm to civilians or whether a target qualifies as a military objective. As I've highlighted before, this is particularly complex in space, where many of the space objects that we can identify serve a dual nature and dual purpose, both military and civilian. So clearly, this concern is exacerbated in this domain. The Outer Space Treaty explicitly states in Article 3, and just as a small introduction, the Outer Space Treaty, as I've mentioned, from 1967, is considered the Magna Carta of space. It's the foundational treaty of the space domain, of the Corpus Juris Spatialis. And in its Article 3, it highlights how international law, including major et minus international humanitarian law, applies to space activities. Yet the unique nature of space necessitates that adaptation of traditional IHL principles to this domain. For example, the principle of distinction requires a clear identification of military objectives, which is complicated in the congested and contested, also obviously also competitive space environment. The principle of proportionality, for example, demands that incidental harm to civilian objects, such as commercial satellites, be minimized and not excessive relative to the anticipated military advantage. And finally, the obligation to take precautions in attack requires that operators suspend or cancel missions if compliance with IHL principles cannot be ensured. And this is obviously a challenging task when dealing with autonomous systems that are operating beyond immediate direct human control, especially when these activities are taking place outside of direct human oversight in the space domain. Further, the dual use of nature of many space assets, as I've said, complicates the application of IHL. And the reason why I'm truly underscoring this is because this is at the core of any kind of this is at the core of all the operators' evaluations when operating in space. Satellites and other space-based infrastructure, which, by the way, have been underlined as being critical infrastructure by many states and around the world, serve both civilian and military functions, making it difficult to classify them as purely military objectives. And this dual use characteristic heightens the importance of careful legal and ethical considerations in targeting decisions and in the targeting process, as the destructions of such assets could have far-reaching humanitarian and economic consequences. Seeing how humankind depends deeply on space infrastructure, as I've said, it has been acknowledged as being critical by many states. And so damaging a space asset might not just, delete the military capabilities that are being targeted in the operation, but might also, for example, cause loss of service for hospitals and other civilian infrastructure, and that are obviously protected under IHL. So accountability for IHL violations involving AI and autonomous systems is one of the most critical concerns, in my opinion. Under the law of state responsibility, states can be held liable for violations of IHL resulting from the deployment of autonomous systems. I would say that there are no direct yet regulations and frameworks pertaining to the use of AI in the space domain, but for the time being, I believe that it's quite possible to extend the general law applicable to AI and autonomous systems to the space domain. And at the individual level, commanders and operators may face also liability for deploying systems in ways that violate IHL, particularly if they act recklessly or fail to ensure compliance with legal obligations. In addition to the legal challenges, the use of AI and autonomous systems in military space operations clearly raises profoundly ethical questions. The delegation of life and death decisions to machines risks eroding human responsibility in warfare, and a concern that is underscored by the already mentioned in this esteemed gathering by the Martens Clause, which emphasizes the principles of humanity and public conscience as safeguarding against inhumane practices. The use of AI in space must align not only with the legal standards, but also with broader ethical principles, ensuring that the human role in conflict decision-making remains central. In conclusion, the integration of AI and autonomous systems into military space operations represents a significant evolution in warfare, offering enhanced capabilities while introducing complex legal and ethical challenges. From an IHL perspective, the deployment of these technologies must prioritize compliance with the principles of distinction, proportionality, and precautions, and more at large, all principles of IHL and customary international humanitarian law. Ensuring that their use does not undermine the protections that are afforded, as I said, under general public international law. By conducting thorough legal reviews, maintaining meaningful human oversight, and establishing robust accountability frameworks, states can navigate the challenges posed by AI in space, while also upholding their obligations under IHL. And this approach is essential, in my opinion, to safeguard humanity's shared interests and maintain the integrity of the legal framework governing armed conflict in the ultimate frontier. To achieve this, I believe that states and international organizations must invest in the development of comprehensive guidelines and collaboration mechanisms for the lawful and ethical use of AI in military operations at large, and also in military space operations more specifically. By balancing innovation with responsibility, the global community can harness the potential of AI while ensuring that space remains a domain that is governed by the rule of law and the principles of humanity. The work of initiatives such as the Open-Ended Working Group on Reducing Space Threats, transparency measures, and legal manuals such as Vomera Manual, Milamos, and other projects that hopefully will focus more on the utilization of AI in the space domain, effectively will be, in my opinion, pivotal in preventing escalations and ensuring the sustainable and peaceful use of outer space, not only for the current generation, but for all those to come. So as AI-driven systems continue to ever more shape military operations in space, states must remain vigilant in balancing the pursuit of strategic advantages and achieving the high ground with adhering to international legal norms. Ensuring that space remains a domain of stability and security is critical, and not only for national interests, but also for the collective future of humanity, and, as I've said, to respect the Outer Space Treaty. Thank you very much to everybody, organizers, participants, other speakers. It has truly been a pleasure to be given a forum to present my thoughts on this. And I hope that maybe I sparked some interest in space law, which is generally speaking a very niche area of the law. Thank you very much.
Thank you so much, Mr. Rahul. Please keep with us this bonding. We would like to invite you, and I hope to see you on 11 January as well. And now we will move to the next speaker, Professor Solomon Tadisi from Ethiopia. So the floor is yours. After your speech, we will start with the presentation. Will be followed by Xiyan from China. Yes, the floor is yours, sir. Before we start with you, we would like to brief about your profile a bit.
Sure, sir. Thank you, sir. Good morning, everyone. It is indeed my pleasure to introduce today's distinguished guest, Professor Solomon Tadise, with an illustrious career in academia and law. Assistant Professor Solomon graduated with a Bachelor of Law from Haramaya University in 2009 and later earned a Master's in Public International Law from Addis Ababa University in 2016. Currently, he is pursuing a PhD in law at the prestigious National Law University in Bhopal, India, focusing on refugee and humanitarian laws. Beyond his academic achievements, Solomon has dedicated his career to advancing legal education and justice. He has served as a legal expert, a trained judge at the Ethiopia's National Judicial Academy, and as a corporate lawyer. He has held leadership roles at the Madda Avalabo University in Ethiopia, where he was the head of the law department and the dean of the law school. He also played a pivotal role in establishing the free legal aid services, assisting vulnerable groups such as women, children, and persons with disabilities. His contributions extend to research and publications in the areas such as international trade, rural land law implementation, and regional trade integration. Furthermore, he is a recognized advocate with numerous certifications in ethics, governance, and human rights from esteemed institutions around the world. Undoubtedly, Sir brings a wealth of expertise to our gathering. We are honored to have him here share his insights and experiences with us. Welcome, sir.
So the floor is
Thank
yours.
you.
Yes.
Okay. Am I audible? Yeah.
Yes.
Yes, sir.
Yes,
are
you're
audible.
audible. Please proceed.
Okay. I'm honored to speak the topic that related to is AI, international humanitarian law as well as the military law. So my focus is on the experience of Ethiopia, especially on the militarization, humanitarian law, and the role of AI, particularly in applying precautionary principles in a conflict zone. In order to share the experience of Ethiopia in this regard, over the past 4 years, Ethiopia has experienced internal armed conflict. As most of you know that, especially from 2020 till 2022, in the northern part of Ethiopia, there were serious armed conflict, internal armed conflict, quote unquote. Neighboring countries also involved in this war. After that war was concluded by Pretoria Peace Agreement in 2022, another war is also started in the central and southern part of the country, especially in Oromia region and in Amhara region. This region covers almost 70% of the total population of the country. So when we come to the issue of AI, in this armed conflict, particularly AI automated drones and AI surveillance system were used. So I try to see these issues in practical terms, how these AI technologies affect civilian and competent also. So when you see the Ethiopian context, especially in 2016 till 2018, there was Ethiopia witnessed widespread civil disobedience in the place that Amhara and Oromia regions that as I have said before, the two largest regional states. Then the protest led to the resignation of the former prime minister, and the new prime minister was taking the power, Prime Minister Abiy Ahmed, who was win the Nobel Prize in 2019. However, while he was, after he raised his power, he started, or there is disagreement, political disagreement with the former dominant political party, the so-called Tigrayan People Liberation Front, and culminating in devastating war for 2 years. Similarly, at that time, what was happening is that AI technology, particularly from the very beginning, Ethiopia was not used. Since this war started, the government tried to use automated drones, either supplied or bought from United Arab Emirates, Turkey, Iran, and China, which played a vital role in changing the nature of the war. So what was happened at that time is that TPLF forces are trying to advance to the capital and they are reaching around, they are far from the capital, around 115 kilometers. Then after this drone try to use, or AI technology try to use by the government, the advancement of these forces, they are retreated back to their place. Similarly, in current war held in Amara region, which started in 2023, as well as in Oromia region, started in 2022, government are frequently using this AI technologies to stop the expansion of these forces to take over the central government. So there are, before going to see, obviously, of course, government is using this drone attack and taking an advantage of military advancement. However, let us look how these AI automated drones surveillance, systematic surveillance systems relate or evaluated in terms of ICHL. Obviously, in the principle of distinction and proportionality, principle of necessity, principle of humanity, they are essential IHL principles, obviously. So there is no law which prohibits the use of AI in international law. So with regard to principle of distinction, the only obligation that the state may have or the warring parties may have is implementing the principle of distinction. Distinction, it means that we should have to distinguish civilian and competencies. However, while we using AI, obviously we pursue or we assume that AI technologies are exact in targeting military operations or military targets. So, however, practically what we have seen is that they are not free from misidentification, and since they are using AI logarithms, they may lead unlawful attack on civilians also. With regard to principle of proportionality, of course, majority of scholars argue that more than or relatively compared to human, AI technologies are less incidental harm to civilian, but this is not always true. We'll see later. With regard to principle of necessity, also attacks using AI technologies they are designed to mitigate the arbitrary or discriminatory attacks, of course, but when we see these practical issues in Ethiopia, things may not be as we perceived. With regard to precautionary measures also, in densely populated areas, in high-risk areas, we may not obviously use these technologies because of they are, or even though they are exactly targeting the system, but still there is a limitation on these technologies. So when it comes to Ethiopian context, exactly what is happening is that there is still uncertainties, even though AI technologies are promoted that they are certain in some extent than a normal circumstance. There is uncertainties, and irreversible harm is observed in Ethiopia currently due to the use of automated drones and AI surveillance systems. Also, as of this, civilians, refugees, and others also find themselves in the conflict zone, which erodes their safety and dignities in current Ethiopian armed conflict. Of course, for instance, officially, government say that we are distinguishing, we do have the capacity to distinguish competent from civilian in this armed conflict. But practically, we are see civil casualties occurring in the current armed conflict in Ethiopia. Because, for instance, if you see the report of Human Rights Watch and other international organizations, they are showing that a number of civilians are attacked by AI technologies, especially on drone attack. However, whether this thing happened due to the reason that misuse of technology or whether it's related with the technology itself, it needs an investigation in this regard. So when we see the impact in general, for instance, this kind of impact on refugees, because Ethiopia is currently hosting almost 1 million and more refugees. So there are a number of refugees in Ethiopia, and refugees are also not free from the effect of armed conflict in current armed conflicts in Ethiopia. For instance, in Amhara region, there are almost 2 refugee camps. There are still war around refugee camp. In northern Ethiopian war which was ended in 2022 also. Even I myself interviewed individual refugees. They told me that there were sorry.
Please proceed. That is
Okay. In northern conflict, in northern Ethiopian conflict, even I try to interview survivors, refugee survivors. They told me that there were drone attack in around refugee camps, especially in Tigray region. So particularly refugee camp in Shemelma, Maini, and other places, refugees were also subject for attack. Actually, at that time, what was is that leaders of the opposing armed group, they are crossing around in the way that the refugee camp is. There is a road, and they are crossing that road, while government is trying to attack those officials, maybe two, 3 individuals. Drone attack was committed on the refugee campus. So this was the incident what we have. Generally, automated AI decision-making in military operation obviously complicates the thing. If we leave everything to AI, it might be difficult, and the situation of civilians may be in question. And also we don't have any mechanism to control the misuse of AI technologies in the increasing the risk of collateral damage. Also creating new wave of civilian displacement due to government assuming that taking an advantage of these technologies, they are using frequently these technologies on their counterpart. So this kind of thing also, in other way, result a new wave of civilian displacement, including refugees, which is dispersion, obviously, and undermining the humanitarian assistance in armed conflict areas, as well as currently what we are observing, especially in Amhara and Oromia region, is that civilians are in terror of whether drone will come and attack them, because they don't know at what time this drone and the AI technologies may be used by the government. So this was the incident of Ethiopia. Obviously, the law, Ethiopian Defense Force proclamation also promote using of technologies, obviously, but the issue is that it might be difficult to get a solution in this regard. So my recommendation in this regard is that retaining human control over critical decision to prevent unlawful action may be necessary, and state may not only relying on these technologies and involvement of human being from the military operation. Maybe it is difficult and it may cause danger on civilians. And also, as to my suggestion, global regulation governing AI in armed conflict is essential, and it must be introduced. So this include promote precautionary principle as a cornerstone of responsibilities in AI deployment. This is all about my idea. So thank you very much. If you have any question, I will reply on that.
Thank you so much for your comprehensive thought. We have a lineup of outstanding paper presenters today. We look forward to have an engaging discussion with expertise and paper presenters. Each presenters will get 15 minutes to present their papers, and 5 minutes will be for questions and answers. And as we continue, without further ado, let's begin with the first paper presentation in the morning session. It is my pleasure to invite Ms. Yan Si, Associate Professor and Director of Military Law Research Institute at the School of Law, Gansu, University of Political Science and Law, China, will present her topic on Chinese perspective on military AI and international humanitarian law, and that with the lens of precautionary principle. Ms. C, I would like to invite you to take the floor and present your paper.
Okay, good day to all distinguished participants. Esteemed experts, it's really my great honor to participate in this great conference. Before diving into the subject at hand, I would like to briefly introduce myself. I'm Yan Cui, Associate Professor from Gansu University of Political Science Law. I will also serve as a joint researcher at the Military Law Research Institute at China University of Political Science and Law. My research focuses mainly on international humanitarian law in China, and also I was honored to serve as observer of International Code of Conduct Association, which works to ensure the private security companies to respect on IHL. My academic and research work primarily focus on international humanitarian law, human rights law, and also the legal and ethical challenges posed by technological innovation in the military domain. I was deeply involved into researching some implications of also private military companies and the regulations of military technologies and protection of national and international security. I also have been engaged in a number of significant projects, including research on maritime security, the Belt and Road Initiative, and also global risk assessment. And also, I would draw on the discussion of emerging capacities of military AI, international humanitarian law, and precautionary principle. Also, at the same time, I engaged in a lot of moot courts, mainly in the national region in China, especially on the JSSLC moot court competition, and also international humanitarian law moot court competition, and ICC International Court of Justice competition. On these moot court competitions, I serve as a judges and instructors for many years, and also it's a great tools to train the international lawyers as well. Also, last year, I participated the 15th advanced anniversary. It's called 15th Advanced IHL Seminar on Academics and Policymakers. It was held in August 28th in Geneva, mainly organized by ICRC. So the seminar is really enriched my understanding of international humanitarian law and equipped my knowledge, and also the important issue on military AI also addressed on this seminar. So it's very important and very predominant topic. And also a lot of materials on international humanitarian law books, and also the commentary of Geneva Convention, Common Article 1, Common Article 2 and 3, and the 4 Geneva Conventions and their protocols. The topics this covered every aspect of international humanitarian law. So I really appreciated the great work and had done by ICRC, and especially on the development and implementation on the international humanitarian law, and also on the military law, and also on the treatment of prisons deprived from the liberty and armed conflict. So on this topic, I also would like to. It's truly my great honor to participate today's event at this distinguished international humanitarian law webinar with you experts. So I was really grateful for all of you to take the time to engage in what I believe is predominant and profoundly important conversation. So today I will address the intersection of military artificial intelligence, international humanitarian law, and the precautionary principle, especially focusing on the China's position. Given the significance on the issues of global security, humanitarian concerns, and ethical governance, I think the discussion is both timely and very crucial. We are witnessing a time when technological innovation in warfare is advancing at the unpredictable pace. So AI-driven systems are increasingly being integrated into military operations. So it arises a lot of crucial questions. How can we ensure the AI system comply with international law? How do we prevent the indecent harm and also the causes by autonomous military technologies? And most importantly, how do we navigate the uncertainties responsibility to apply the precautionary principle to safeguard humanity and international peace? At the heart of China's position, especially on AI, military AI, it lies in the blend of traditional philosophical values and strategic foresight, and also a deep ethical responsibility that is rooted in China's history and cultural outlook. So to fully understand China's approach, it's very essential to consider the historical and philosophical influences. So that will guide the military strategy and technological development. So China's thought is very profound, shaped by Confucian, on the Taoism and also the militarism of Sun Tzu. So these traditions emphasize harmony and balance and the military minds of the conflict. So Confucianism is particularly teaches the importance of moral duty and the protection of life. So these ideals align with closely with the core principles of international humanitarian law, which seeks to safeguard the civilian life and limit unnecessary suffering during conflicts. Sun Tzu, his thought is also teaching us on the warfare, stress, achieving victory, and also with minimal harm, and which also aligns with China's cautions and also its deliberate approach to military AI. So rather than rushing to deploy new technologies, China prioritizes careful planning through the testing and the strategic restraint. So the principles are fundamental to ensure the AI-driven military system is very useful for responsible AI and in compliance with international norms. So this is a historical and philosophical context. So and also I would like to draw in my paper and to shape how China views the role of military AI. As it is a very important tool, and it also must be witnessed with a great caution and awareness of its potential consequences. The lessons drawn from China's own history is very remarkable. It marked by both international conflicts and also by the internal struggles throughout all its history. So it leads to us to deep understanding of the vast consequence of the conflict. So consequently, China's approach is one of the responsibility and the restraint, and always mindful of the need to protect humanity while pursuing technology innovation. The second part of my paper is mainly draw on the military AI and international humanitarian law, is built on the key principles on the protection of individuals during the armed conflict, the principle of distinction, principle of proportionality and necessity. And these principles also guided military operations. It ensures that the forces is applied very distinguishing between combatants and civilians, and also it's limiting the harm of those who do not directly involved in the hostilities. However, the integration of AI system into military operations presents significant challenges to the application of these principles. For example, on the distinction principle, some questions arise on can AI system effectively distinguish between combatants and civilians, especially in complex and rapidly changing of conflict zones. And also the principle of proportionality also arise, such as the questions on can autonomous system fully address the proportionality of their actions. So AI may not always understand the broader conflict and the consequences of this decision. So it leads to an intended overreach. About the principle of accountability, also the questions of when AI system violates IHL, who is accountable? So it is the machine or the programs or the military commanders who will deploy the technology. So in recognizing these challenges, the China's approach is also it advocates the human-in-loop approach to the military AI. This means that the autonomous weapons should remain under the China's oversight, under the human's oversight. It will allowing for human intervention and decision making is very crucial. It's very crucial. So this approach will ensure that the ethical principles of international humanitarian law are respected, and also it will uphold the development and deployment of AI system in military operations. And also the Chinese principle on the precautionary principle. It's very fundamental concept. It's especially important in managing risks associated with new and emerging technologies. It's particularly when these risks are uncertain and unpredictable. So this principle suggests that in the face of significant uncertainties, we should take preventive action to prevent and the potential to avoid and prevent the potential consequences. So in the context of military AI, the precautionary principle urges us to act with the foresight and caution, and especially to give the unpredictable and potentially consequences, disaster consequences to deploying the untested AI-driven weapon system. So China's embraces controlled innovation and military AI development. So it's rather than rushing into deploy very autonomous weapons, China advocates that a very gradual, careful development, and also with rigorous testing to evaluate, to ensure the technologies do not pose unforeseeable risk. So central to this approach is the importance of human oversight from the ethical perspective and also from the legal perspective. So even AI technology are integrated into military operations, China asserts that human decision makers must always be involved. So the involvement of human is to ensure the AI system remain under ethical and legal control. So this approach reflects a fundamental belief in the sanction and especially on the sanction of human judgment in the most crucial situations. So moreover, China also advocates the international transparency in the development of military AI. The global cooperation is very essential to create a regulatory framework that align with international humanitarian law to ensure the military AI is developed and used responsibly. So in accordance with shared ethical norms. Also, as the military AI involves, China's position on global governance of military AI presents a global challenge that requires the coordination of international response. So in this regard, China also calls for the multilateral governance to regulate development of military AI. So some key aspects of China's position include international cooperation. So China recognizes the development of military AI is a global concern and also requires the input from the wide range of stakeholders, including governments, international organizations, academics, and civil society. And also, on the risk management part, China also supports a tiered approach to military AI development to ensure the technologies are not deployed prematurely. So this must be the ongoing research to assess the long-term risk of military AI to prevent the intended conflict, the intended escalation in the conflict. So in conclusion, so China's approach to military AI is rooted in the ethical responsibility, strategic caution, and also commitment to the international cooperation. So by embracing the precautionality principle, China advocates that for a very responsible, measurable pathways forward. So we must balance the innovation with and also innovation of AI system and also with ethical considerations, especially on the military AI, to ensure that military AI is developed and deployed in a way that protects humanity and adhere to international humanitarian law. So we could look at to the future. The development of military AI must be guided by the principle that protect human life and to ensure the strategic stability and the respect of the laws of war. So the precautionary principle is not merely a guidance, it's a very call for action for the foresight and responsibility, and also the unwavering commitment to the peace. So I sincerely thank you for your great attention, and I really appreciate for the organizers to give me the chance to present my paper and share my insights. I look forward for future discussions on how do we collectively address the crucial challenges. Thank you very much.
Thank you so much. Thank you so much for the comprehensive discussion over the Chinese perspective. Is there any question concerning this presentation? I'm seeking questions from audience. I would like to repeat once again. Is there any question concerning to this presentation? Seeing none, we shall move.
Sir.
Yes, please proceed with your question.
Sir, I have a question.
Yes, please.
Thank you, sir.
Yes.
Yeah. Does the China approach to military AI and its education of the precautionary principle threaten regional stability, and it put pressure on neighboring countries like India to compromise on their ethical and legal commitments in military AI development? Even India's emphasis on ethical AI development and adherence to international norms. So is it clear, or should I have to repeat?
Could you repeat your questions once again?
Yes, sir. So does China's approach to military this interpretation of precautionary principle threaten regional stability and put pressure on neighboring countries like India to compromise their ethical and legal commitments in military AI development?
Ms. Yasinsi, would you like to reply to this question?
So sorry. May I clarify with your question is mainly on the China's perspective and a comparison between the Indian's perspective? Am I correct or hello?
No. I'm talking about the regional stability.
Yeah.
So China perspective
Put your
of
question
precautionary
very
principles
slowly.
threaten the regional stability. Yes, sir.
Yes.
She can type it on the chat.
Can you type on the chat box so that she can understand your question?
Yeah, sure.
I'm not sure how to understand. Yes, if you type it. Is there any other question, second question, tell she type on the chat box. We would be glad to hear a question from you.
How do you achieve the emotional motive of AI system? Emotional. That's a very, very good question. Thank you very much. That's China's approach of military AI and its interpretation of precautionary principle threaten regional stability and put pressure for neighboring countries like India to compose as ESCO and legal commitments in military AI development, giving Indians emphasis on the ethical AI development and the adherence to international norms. So thank you very much for your question. I really appreciate for the great participants and really appreciate for your question. So from the how do China achieve the emotional cognitive of the AI system? I would like to emphasize on the China's ethical aspects, especially on the military AI. So as I addressed on the China's historical and philosophical traditions, so particularly on the Confucianism, on the Taoism, and also the teaching of Sun Tzu, it emphasized the ethics, the harmony, and minimization of the conflict. So these principles that China is adopted its approach on the military AI development. So China's historical experience also, such as Opium Wars and the Chinese Civil Wars, also have the deep respect of the stability and also to the respect of IHL. So these factors also influence China's strategic thinking. It lead to adopt the controlled and incremental approach to the military AI. So that's my answer to the first question. And also the second question is, does China's military AI and its interpretation of the military precautionary principle threat the regional stability and put pressure? Yeah, I think this is a very, very good question. Put pressures on the neighboring countries like India. The main challenging of the, as I addressed, is application of international humanitarian law principle is main challenging. So such as the distinction principle, the AI system must struggle to distinguish between the competence and the non-competence in the real cases and in the real neighbor cases as well. And also for the autonomous AI system, also AI system must have the conflicts to without human oversight, how to accountable for determining who is responsible for AI actions. So these questions especially especially addresses in different challenges.
She has got a problem.
Okay.
Or
Thank you. We shall move
And how to interpret the precautionary principle threat. So I think the the precautionary principle also give us some advice that when the risk of new technologies of AI is uncertain, so we should take steps on how to minimize the potential harm in the context of military AI. So this following, and also the ethical considerations, the transparency, the oversight is very important as well. So on this principle, China seeks to mitigate the risks to prevent the unintended consequences from the AI in the warfare, in the diplomatic warfare. Yeah, thank you very much. If my answer is not complete, I would like to contact with you further by email and further correspondences. Thank you very much.
Thank you so much. You have done with your answer. Thank you so much.
to just add to
Thank you so
Abhinisha,
much.
sorry to interrupt. I can just tell, join Yan Kui by telling that I want Abhinisha to look into yesterday's video where Dr. Srinivasalu explained about the modal AI with the invent of new technology where it can sense the emotional quotient as well. So whether it is in India or in China or any other country, this is the new technology. I would like her to listen to him again for maybe to complete her answer to the question. Thank you.
Thank you very much.
Thank you so much for joining us. Okay, we shall move to the second presenters, Nandana Rajesh, research scholar, School of Legal Studies, Kosa Kerala. Her topic would be the warfare in the age of AI, autonomous weapon system, and shifting landscape of international armed conflict. Yes, you must be cognizant of your time and use your time judiciously. Please proceed.
Good morning, everyone, respected organizers and everyone present here. So, before I start with my topic, I would like to take you to a movie which I had watched, The Terminator, in the year 1992. So, this movie actually starts with the humans are using machines for doing war, and what happens was that at the end all the humans would be dead and machines would be fighting against each other. So in 1992 it was a movie, but now it is becoming a reality. So that is where we have the present topic, that is the use of AI, humanitarian law, and that is where my topic comes into play, that is warfare in the age of AI, autonomous weapon systems, and the shifting landscape of international armed conflict. So, when we speak about the autonomous weapon systems, we can see that the technological achievements that have actually led to the establishment of AWS, and we can see the growing role of AWS in modern warfare. And so that is actually showing a significant shift from the traditional human driven combat strategies to a more technologically autonomous future. So these autonomous weapon systems, they are actually powered by AI, then machine learning, robotics, and sophisticated sensors. So it actually helps them to perform the targets based on program algorithms or some learned behavior based on the data which we provide. So we can see that there are many positives, such as the changing military strategies, and also they can successfully execute a precise strikes, such as minimizing the chances of collateral damages or to achieve operational efficiency. And also we can see that AWS also enables fast decisions and also process very large amounts of battlefield data, and also we can see that there can be very instantaneous changes and all. So this kind of operational autonomy that is actually making an attractive opinion for the militaries, so that they can have a very technological edge. So basically, we can see that, but the increased use of AI that is actually causing considerable ethical as well as legal concerns. So actually, the delegation of life and death decisions that we are giving to machines. So we can say that this AWS that is actually lacking human oversight, and also further concerns which relate to the accountability, that is especially when they inflict unlawful harms, they are actually violating the international humanitarian law. So presently there is no such existing legal framework, but still we can see that when we look into the principles of international humanitarian law, such as distinction, which requires that the parties of an armed conflict must distinguish between the combatants and the civilians. So we can say that AWS in its current form that is actually lacking a nuanced understanding of the context and the human soldiers which the human soldiers bring to the battlefield. So the AWS, they may fail to differentiate between combatants and civilians, especially in an urban warfare. And also when we look at the principle of proportionality, we can see that in AWS, the harm which they may be caused might not be proportional. And also the principle of necessity, that is, AWS may have the capacity to carry out operations without a clear evaluation of the need for force in certain situations. But in other cases, we can see that lack of a human commander's judgment that might make AWS to make use of force where it is not strictly necessary, such as targeting targets which may not actually pose no military threat, or even when they are causing a military threat, we can see that AWS would take decisions. So another significant challenge, we can see that there are many legal gaps. That is when we look into the Geneva Conventions and all, we can see that no such law is being incorporated. Also, when we look into the ethical implications, also there are many enormous ethical implications. So historically, we can see that the application of the use of force and all, that was by the humans understanding of specific context and all. So when this is delegated to machines, they may actually lack the compassion, the moral reasoning and all. So another major ethical concern is also the civilian harm. That is, for example, a decision making algorithm that may fail to account for the presence of non-combatants, and that may inadvertently be grouped with the legitimate military targets. And also we can see that the concept of killer robots, they refer to autonomous systems which can identify and attack targets without human interference. So we can see that the development of this autonomous weapon systems, especially such as in making these life death decisions and all, that is actually a very dangerous step towards dehumanizing warfare. And also, we can say that there have been many international responses and regulations of AWS. So this the UN has been a central actor in such debates. And also we can say that in 2014, the UN actually launched a group of governmental experts to constitute the convention on certain convention under the CCW, that is the certain conventional weapons. And so what they did was that they issued many reports stating the about the concerns caused by AWS, and also calls for its regulation. Also, other international forums, including the ICRC, they have also entered into debates and emphasized the relevance of the compliance of IHL in the light of the emerging technologies. And also one of the other, and also we can see that in 2013 there was a campaign to the killer robots campaign to stop the killer robots, and where a coalition of NGOs argues that these AWS, they may open up a path of future where the decisions related to the use of force get out of the human control and thus can be used indiscriminately, thus violating the principles of international humanitarian law. But even if a regulatory system is created, we can see that there are reasons why international laws concerning AWS cannot be easily enforced. That is, the question of state sovereignty might come. State may oppose the international regulation that would undermine the capacity to develop and deploy the military technologies, and also these are all some upcoming issues along with it. So when we look into the future of warfare, we can see that the capability of a more rapid and precise strikes with fewer casualties to humans can make AWS an effective instrument for projecting power with minimal risk to users. But and also what we can do is that a blend of a preventive measures and technological safeguards will be required to mitigate the risk which are incurred through AWS. So establishing international agreements, then regulating the design, deployment, and use of autonomous weapon system is also an important one. And also the question of liability would also be coming in here. To address the complex challenges, the more important measure would be the development of international treaties which regulate the use and deployment of AWS. So these treaties should include clear definitions of what constitutes autonomous weapons, the boundaries of the usage, and also stringent ethical guidelines for their operations. And also another major recommendation is to include AI transparency in the design. That is, the algorithms guiding the autonomous weapon system that should be explainable and auditable to ensure that the decisions are understandable by the human operators. And also on a technological level, kill switches can be made. That is, these are mechanism which will act as a safety net for AWS to avoid acting unilaterally without any human oversight or breaking the international humanitarian law in the heat of the battle. And also additionally, the development of non-lethal autonomous weapons to be used in peacekeeping or surveillance operations. They may provide as an alternative that reduces the risk of escalation or even unintended casualties while still using the benefits of automation. So in conclusion, we can see that this AWS, they hold both great promise and significant challenges in the modern battlefield. And also they offer precision and efficiency, but the deployment of such systems brings forth critical legal, ethical, and security concerns. So what the current legal framework, such as the international humanitarian law, they do not adequately capture AWS reality, and they have loopholes that need to be covered by the international cooperation and law revision. And also, my paper, it actually calls for the development of legal robust norms and
Thank
ethical
you,
guidelines.
Nanda, you have done with your time. Thank you so much. We are
Yes.
looking for questions and answers. Answers from you, the questions from the audience. Is there any question concerning to Nanda's presentation? Is there any questions? Seeing none, we shall move to the next presenters. Following Nanda's, we will hear from the Dr. Raval Dempal, Associate Professor of Law and Director in charge at the School of Criminal Law and Military, Rashtriya Raksha University, that is Ministry of Home Affairs, with Mr. Chavan Sani, who is a PhD scholar at the same institution, who will present the topic on the legal and ethical implication of autonomous weapon system under international humanitarian law. Now,
Hello?
yes.
Am I audible,
ma'am.
sir?
Yes, you're
Thank you
audible.
so much. Yeah.
Yeah, welcome.
So,
Please proceed.
so good morning, ladies and gentlemen. It's a privilege to participate in today's worthy discussion, and my topic is on the legal and ethical implications of autonomous weapon system under the international humanitarian law. I extend my heartfelt congratulations and a warm greetings to the organizers that are Uni of Nairobi Law School, ICRC, Unifor, JSS Law College, Mysore, and Institute of Policy and Research for addressing this critical and sensitive topic through such a timely webinar. In an era where technology not only advances humanity but also imposes profound challenges on civilization, it is imperative to deliberate on the implications of systems that have the potential to turn the entire globe into a battlefield with their fire and forget capabilities. I am Dr. Dimple Rawal, Associate Professor of Law and Director of the School of Criminal Law and Military Law, Rashtriya Raksha University, an institution of national importance, Ministry of Home Affairs, Government of India, along with my co-presenter, Mr. Sunny. I look forward to exploring the nuances of this complex and urgent subject. Let us dive into this thought-provoking conversation as we reflect on the balance between technology innovation and the ethical responsibilities that underpin international humanitarian law. The rise of AI and AWS marks a transformative shift in military technology. This system, often referred to as fire and forget technology, operates independently, raising profound legal, ethical, and policy challenges. This presentation addresses the critical implications of AWS under international humanitarian law and the urgent need for a global regulatory frameworks. This presentation alerts regarding the dual-use technologies of AWS and how these relate to impacts on the arms race as well as international security. The paper examined the regulation of AWS by international organizations, including the UN Convention on Certain Conventional Weapons, and examines current available legal frameworks, including Article 36 of Additional Protocol 1. It provides sweeping legal, moral, and policy recommendations that would contribute to robust international cooperation, transparency, and accountability system. The main requirements at this point in time to come up with a universal definition and classification of AWS. Today, if we talk about the definition, that there is not a universal definition or meaning ascribed to the term AWS. However, according to US Department of Defense, they defined an autonomous weapon system refers to a weapon system that can, once activated, identified and engage target with very minimal or no human intervention during the cycle. Yes, according to ICRC, AWS means any weapon system with autonomy in its critical functions. In other words, it is weapon systems which can choose, search, detect, and identify, track, and select and attack. While framework like the US Department of Defense states the needs for human oversight, and even they've come up with some, vague sort of definition. So conventions, protocol, and IHL talks and arms control treaties historically focus on hardware, neglecting the critical role of software, which is in AWS. With this, I will invite my co-presenter, Mr. Sunny, for further deliberation. Mr. Sunny, over to you. Hello?
Mr. Sunny?
Yeah.
Yes, I'm audible, sir.
Yes, you're audible, but you're not so much clear visible. You're audible, yes. Yes, now you're fine.
Well,
Yes. Yes.
Is I'm audible?
Yes, you're audible and visible now. We can see you.
So thank you so much, ma'am, to give me this opportunity to present this topic at the international level. So first of all, I would like to introduce myself. My name is Sunny Chauhan, and I am a PhD scholar pursuing my PhD under the supervision of Dr. Dimple Rawal at the Rashtriya Raksha University. So basically, the thing I will start from the few. I have only a few seconds that I will discuss about that. Yes. So the integration of the integrations of artificial intelligence into the autonomous weapon system, AWS, represent a significant legal and ethical challenges under the international humanitarian law, such as advanced AI technologies like machine learning, deep learning complies these issues, further creating a responsibility gap. Traditionally, IHL framework are designed for the human actors only. So what is the thing is that there is an integration of AI plus also autonomous system also having a autonomy itself. So there is a creation of a responsibility gap. Who will be responsible in these certain types of things? The machine itself is responsible. AI is responsible, or person who is a person who is performing the AWS, who is the responsible. There is a responsibility gap of these. So the key principles such as the distinctions have been mentioned under the Article 48 Additional Protocol 1, which mandates there is a differentiate between the combatant and the civilians also. And we have another principle, that is a proportionality, have been mentioned under the Article 51 subclause 5, which prohibit there is excessive civilians harm relating to the military gains face serious obstacles due to AWS unpredictability and its speed. If there is a concept of at the international level, there is a concept of meaningful human control, which means that if autonomous system have what having that autonomous system or itself having a autonomy, but there should be a minimal or there should be a control of humans. So there should be a at least the concept of meaningful human control. So the current emergence of AWS, the rise of autonomous weapon system powered by the artificial intelligence and the machine learning, it reshaping the legal and ethical landscape of warfare under the international humanitarian law. So the AWS can operate without direct human oversight. That raising a serious concern about under the international humanitarian law, such as the distancing, proportionality, and the necessity are the main core principles of international humanitarian law. In the year of 2022, ICRC has published a report that they have mentioned about what is the AWS. So at that time, they have they have published a report where autonomous weapon system uses artificial intelligence for the facial recognition that can identify the target with low confidence at the level of 65%. So this was at the year of 2020 or 22, but when we see the 2024 2025, it's predictably goes up to the 90 to 95% also. So it is a very dangerous types of weapon will be considered as ICIs also have they give their opinion, and that should be complied with the international humanitarian law. So there is no worldwide definition of autonomous weapon system, but ma'am suggested that as US department have been mentioned and the ICRC have been mentioned the definitions of international humanitarian law. So if we see the classification of AWS, so there are mainly 4 types of classification have been mentioned under the international at the AWS. So firstly is there the autonomous weapon system. So the autonomous weapon system is considered as a killer robot. This system is a more dangerous, one of the most dangerous types of AWS we can consider as that can operate completely without a human intervention. So there is no requirement, at least 1%, there is no requirement of human intervention. They can actively choose, target, and attack as per their own programming language. So that is one of the most dangerous weapon. That is a fully autonomous weapon system. Second is that is semi-autonomous weapon system. So semi-autonomous weapon system is a type of weapon system there where there is a certain requirement of human control is required. So there is a requirement of certain things. So there should be minimal or there should be at least 50 to 60% human intervention should be there. That person should be controlled that the things. Third is the autonomous control weapon system. So these systems are not fully autonomous, but they allow to operator to fire the weapons remotely. They rarely oppose the human judgment of each action, but the advantage of this advanced technology support for the targeting the environment for the engagement. And fourth is the lethal autonomous weapon system. Is a lethal autonomous weapon system is a specific category of autonomous weapon system designed for the especially for the combatant. They can identify and engage the target using the lethal force without the direct human oversight. So there is a technological advancement in capabilities in autonomous weapon system. First is that it can precise and decision making through the artificial intelligence. So AWS mainly can itself having a precise decision making through the its artificial intelligence. Second is that enhanced autonomy through the machine learning. Autonomous weapon system is designed as it is self having the autonomy that can search, select, and destroy the target itself without any human intervention. Third is that there is an integration of advanced sensors and recognitions of technology. So autonomous system itself having a integration of advanced sensors recognize technology, which challenges the core principles of international humanitarian. There is a distinction, proportionality, and the necessity. Fourth is that human out of the loop concern as an ethical implication. As previously mentioned, that there should be a principle of meaningful human control should be there, but human is out of the loop in this AWS things. There should be a minimal, or there should be a certain requirement of human, so that target embed should be minimal to the minimum, and there should be no use of dual use of technology among these AWS system. Only for the military persons can be use this technology. And the next legal things will be my ma'am will be discussed. Over to you, ma'am.
Okay, thank you, Sunny. So regarding the principle of proportionality, it has been, thoroughly discussed from my previous presenters as well as esteemed speakers. So we'll be discussing regarding military necessity. Yes, of course, force may only be used against justifiable military targets in order to acquire a particular military advantages, as long as it does not violate the other IHL principles. Yes, when it comes to unnecessary principle of unnecessary suffering, so combatants are protected from cruel treatment and the use of weapon that inflicts needless harm by the ban of unnecessary suffering. Martin clause is there. So the Hague Convention 4th of 1907 contained the Martin clause, which state that the rules of public morality and human value takes precedence over previous treaties in situations that are not specifically covered by them. So as a new technology, AWS is in a legal limbo that is isn't specifically addressed by the majority of IHL treaties. Legal reviews under Article 36 of Additional Protocol 1. So Article 36 of this protocol of the Geneva Convention provide that government shall undertake appropriate study to be satisfied that the weapons, methods and means of injuring the killing shall comply with applicable rules of IHL. So therefore, such AWS system will have to be critically reviewed in the development process as well as in their actual working scenario. When it comes to legal and ethical concern regarding autonomous weapon system, so the development of AWS, which known as lethal autonomous weapon or killer robots, indicates an important shift in the subject of conflict. With the use of AI, AWS may function autonomously, frequently without direct human intervention or assistance. Sometimes it can be more hazardous by saying that for the sake of political assassination or for the sake of particular target, it could be more hazardous. So in very tough to interpret as well as apply the law with AWS not having a common understanding, the ICRC has developed a concept regarding AWS which appears that such systems are those lacking meaningful human control over their main functions, including detection and engagement of targets. So here all states or stakeholders or NGOs role comes into play, that to come up with a, we can say principle of consensus to come up with certain regulatory framework mechanism, which is for again universal. So it is in its operation, AWS should strictly adhere to the requirements of IHL such as distinction, proportionality and military necessity. Yes, of course, just ad bellum proportionality, there is a valid just ad bellum concern about the deployment of AWS because the use of force in military operation is seen as disproportionate, contrary to infringing the concept of proportionality, which simply put their force should not be given to the extent that it reflects the proportion to the menace faced. Just in bellow challenges, distinction, proportionality, and precaution. So it is very much difficult for AWS to adhere the just in bellow norms of safeguards, proportionality, and distinction outlined in international humanitarian law. When it comes to ethical consideration, accountability, and responsibility, so if anyone, including the criminal liabilities and state deploying the AWS manufacture programs or military commodities would be held accountable for breach of international humanitarian law or human rights. Human rights law. Of course, their capacity to make rational and ethical decision about the use of life-threatening force is called into question by the employment of AWS in anti-terrorism for law enforcement operation. So, in conclusion, there are several, the role of academic communities and NGOs plays a crucial role in setting the debate about AWS governance. What we people are discussing since last 2 days, having this webinar, which is very much worthy enough and fruitful. Organizations such as campaigning to stop killer robots have made public the danger of AWS and are advocating for them to be banned. Epistemic communities help by providing research-based insights and proposing normative framework for AWS regulation. Non-state actors are shaping the non-state discussion on AWS governance. Organizations like the Campaign to Stop Killer Robot, which call for an outright ban, have highlighted danger of AWS. And if I may not wrong, more than thousands AI experts and scientists, they've taken the oath not to come up with some sort of AWS or not to involve, because it poses a challenge and threat to the entire civilization. So non-state actors, including the NGOs and academic communities, also play an important role in determining the debate on AWS governance. Yes, research and changes are required to address the gaps which the legal frameworks what we are having at present, and the changing nature of AWS investment should consider how AWS affects IHL compliance, ethics, and how. Yes. Yeah.
Thank you so much. There is a
Thank
question.
you. Thank you.
There is a question posed to you that who will be liable for the AWS autonomous weapon system? Who will be liable?
Yes, for that particular technology, yes, any technology and science is always emerged for the betterment of this world order. But when it comes to how to sensibly use of those technology, it ups to wisdom which needs to be understand from the particular states or superpower states when it comes to, or again the global community, how to minimize the conflict when it comes to some sort of battle. Because as I rightly mentioned that IHL and other conventions talks about hardware mechanism, but AI and AWS talks about software mechanism. So the wisdom itself, to be created by particular nations or superpower nations. So and here I would like to mention that why we would held responsible of those scientists or AI experts, rather than to make responsible of such state who are using this challenging or hazardous system. Yes.
Okay, thank you so much. We will move to the next presenter since we are running.
Thank you so much, organizer, for
Thank you so much.
for providing this opportunity to put my words before you esteem. Thank you. Thank you so much.
Thank you, sir. Thank you, sir.
You're most welcome. So we have next presenter. That presentation will be by Nisha Bhaskar, who will discuss determining the sovereign and the laws of war in the era of artificial intelligence. Please take the stage. This is the virtual stage for you. Nisha Bhaskar?
Yes.
Yes.
Am I audible?
Yes, you're audible.
Okay. Thank you. I've put on the camera. I'll be visible in a few seconds. I'm so sorry for the delay. The topic of my paper is determining the...
We would like to see you. I don't see you.
I have put on the camera. It will...
Why we don't see you?
1 second. I think I'm visible now.
Still you're not visible. Yes, now you're visible. Yes.
Okay. Thank you. So the topic I have presented in this research paper is determining the sovereign and the laws of war in the era of artificial intelligence. So we can see there are two variables, that is sovereign and the laws of war. And the scope of the paper is defined by artificial intelligence. The limitation of the paper is that it is under the TWAIL approach, that is the third world approach of international law. So what I am discussing, the major tenets of the paper is defined by the idea that international humanitarian law, the term, the semantics of the term originates from the very Eurocentric idea. Rather than having the international humanitarian law as such, the proposed etymological alternative is the laws of war. The laws of war in itself, the inspiration, the tenets, and the elements would be derived from the legal traditions. Now, the question arises, what is legal traditions? So, legal traditions would be the elements from different contextual, social, and temporal approaches of these traditions, in the sense where they have established themselves over a period of time. So there is an author, Patrick Glenn. Patrick Glenn has written enormously about legal traditions. Now, what I am proposing in the paper, that rather than having one set of derivatives from the evolution of law of war in the Western legal tradition, the approaches and the elements should be constituted from different legal traditions. So different legal traditions, the recognized legal traditions and the works on which have been developing. Indian legal tradition, which encompasses the Indian legal Hindu legal tradition as well, the word that has been used in the ancient contextual term. Then there can be sources from Islamic legal tradition, the Chthonic legal tradition, the Aboriginal legal tradition, the Confucian, that is the South Asian legal tradition, more so the Chinese legal tradition. So these are the legal traditions. Now, what I mean by determining the sovereign in the sense that the very territorial annexation of the concept of sovereign, the Westphalian notion of the sovereign needs to be changed, needs to be revisited in the age of artificial intelligence, because artificial intelligence in itself is a developing entity and evolving entity. As we have understood through the first day, and many people have contributed on highlighted what is the meaning of artificial intelligence. The one important challenge that arises is whether we consider the artificial intelligence, when we talk about the liability, as a humane element, or when we talk about IHL, under the command responsibility. So who would be having the liability of the artificial intelligence vis-a-vis the sovereign? Because as we know, under the international law, the sovereign is something that we discuss on. The sovereign is something that we rely, or which forms the subjects of international law. So when we talk about the sovereign under the international law, we need to understand that artificial intelligence is the new subject of the international law that is challenging the sovereign, that is emerging for the sovereign. Because artificial intelligence is not something that is a machine or a robotics that is defined. It is learning, it is evolving on its own. And if artificial intelligence is actualized in the true sense, it would be the humane alternative. Of course, under the European conventions and under the European Union rules, we have talked about limiting the liability of artificial intelligence, and we do talk about what are the contours of artificial intelligence, whether it would be considered as an human. For example, Japan considers it human, rather than US does not considers it a human element. So these are the things that the paper discusses about core IHL and core sovereignty. So we need to understand the two things, that sovereign and the sovereignty. When I talk about the sovereign, I do mean the states. When I talk about sovereignty, I have discussed in the paper, it means the will of the people. There would be two elements of the sovereign, that would be the internal element and the external element. The external element would be the positive law, the sanctions that we talk about, and the internal element would be the will of the people. The legal traditions would become important when we are talking about the internal element, because the internal element ratifies its sanction from the very people, from the very individuals. And this internal and this legal tradition becomes important when we are talking about the context, when we are talking about the historical understanding. See, semantics is defined by the historical and psychological study of the changes of the language, of the words. When we reserve ourselves, when we reserve the evolution of laws of war within the humanitarian law, we reserve ourselves from taking inspiration from the other legal traditions. While I was working with ICRC, the New Delhi branch, we worked on the South Asian Summit where the book was launched, where we did discuss the different elements from different legal tradition. So African legal tradition becomes one important legal tradition when we are talking about adjudicating, and the question that arose, that who will be punishing. So when we are talking about adjudication, we need not reserve ourselves to some external entity. When we talk about the gacha codes in Rwanda, how the adjudications were done, when we talk about certain tribes, how the tribes and their adjudication, for example, the concept of guilt that forms the fundamental idea of the international criminal jurisprudence or any criminal jurisprudence. The concept of guilt is not present in certain legal traditions. So how do we ascertain, how do we sanction, and how do we try to ascertain the liability in certain cases? This is something that the paper discusses about. Now, for the sovereign, the inspiration, considering my knowledge from India, I have taken inspiration for the sovereign from Kautilya's Arthashastra, which talks about the Saptang theory of the state. The Saptang theory of the state not only talks about the internal factors, but one internal, that is the friend and the enemy. And when we read the modern literature, when we read the comparative literature on the state and the sovereign, even Carl Schmitt talks about this concept of the friend and the enemy, that is the internal and the external vis-a-vis for the times of emergency. And IHL, the war is one of the elements for the time of emergency. So the inspiration from taking the inspiration from Arthashastra, again the questions would arise: what is the authenticity of the element, what is the reliability of the sources? The historical sources would only be accepted when the historical tenets, when the historical ties to that sources is established in the chronological sequence. Not only the literary sources, but also the archaeological sources establish the presence of laws of war in different legal traditions, particularly when we talk about Indian legal traditions. And I've discussed in another of my papers, which I had the opportunity to present at the Dr. Radha Binod Pal's conference at NUJS. They have discussed about how there is presence of laws of war in the Indian legal tradition, and there we do talk about the laws of war vis-a-vis the literary sources as the archaeological sources. So, and it is not only in the Indian legal tradition. When we talk about what is the law of war or what is the law per se, we need to come out of the paradigm that we have defined ourselves. We need to come out of the scope that laws of war would only be derived from the positive or from the natural school of thought. There would be different schools of thought, there would be different interpretation, there would be different values enshrined. For example, when we are talking about precautionary principle, we are talking about defining the liability. Confucius ideas presents a very detailed, elaborate idea on what is virtue, what is liability, and how it needs to be regulated. When we entail that within the law of war, we will have a holistic approach. So what the paper talks about an inclusive idea, talks about a holistic development of the law of war for the artificial intelligence. We need to understand that artificial intelligence in the contemporary is a developing framework. We do not yet have concretized all the laws, and more so, we would not be able to concretize the laws per the AI, because artificial intelligence is not something that has developed. It is not something that will remain at a certain level. It is something that will be evolving, because artificial intelligence, and it's not a recent phenomena. We need to understand that the work has been going on 1950s, 1958 people started 1950s and 60s there was this discussion about artificial intelligence. We have the different IBM projects that started discussing how artificial intelligence would help the human, or would be able to compete with the human. The first challenges that arose was whether the questions that arose was whether artificial intelligence is competent to defeat a human in chess. Now artificial intelligence, when we are talking within the domain of AI, we are directly discussing the challenge pertaining to the weapon. That is one of the main ideas, that is the regulation of means and methods of warfare. So for this we need to have a law that encompasses this, that is not only a sunset clause, that is pragmatic in toto. For that we need to take inspiration from the other legal traditions. See, we all have been discussing about principles must be adhered, but the law can only gain its sanctity when the law is accepted, and the acceptance of the law can only come with the internal element, and that internal element is the will of the people. The will of the people will only be accepting the law when it is reflective of their will rather than a foreign imposition. This is the main idea of the paper, and I'm welcome for questions and answers. I would be providing the answers. Thank you.
Thank you so much. Is there any question concerning to this presentation? Bhaskar did a good presentation over her topic. I may say that she has a good command over the paper.
Thank you.
Is there any question? So seeing none, we shall move to the next presenter. Our next speaker is Dr. Lakshmi, Assistant Professor at the Demodram Sanjeevia National Law University, India. She will be presenting her paper on the usage of artificial intelligence and machine learning in military operations, state's responsibility. So Dr. Lakshmi, we invite you to present your paper. Are you there, ma'am? You're not audible, ma'am. Ma'am, can you? Yes. No, ma'am, you're not audible. Just. Mhm. No, ma'am. Sadly, you're not audible. Disconnect and connect back. Probably might be there is a network issue. Yes. Ma'am, still you're not audible. Could you check out what it would be better this you disconnect once again you connect so that we'll catch you with we will go with the next presenter, then you will get a time to come through. So tell Dr. Lakshmi join us. We will hear from Mr. Virendra Pratap Singh. Are you there? Mr. Pratap Singh?
Am I audible, sir? I'm
Yes,
visible?
you may proceed with your paper.
Okay. Thank you. I'll just upload my PPT if that's all right.
Yes, you can share.
Okay. Thank you, sir. I'll just upload it. The host hasn't allowed me to share the PPT. Could you grant me the access?
Let me try to allow you. Go to share. Okay, go to share. No, from there. Yes, now you can proceed.
Okay. Thank you. I'll just upload it.
Yes.
Is it visible?
You need to double click. Yes, now you are visible.
Mm, Okay. I'll just start in a second. I'll just present it.
Yes, you may
Is it
proceed.
okay? Okay. Thank you. Good afternoon to everyone, all the esteemed speakers as well as the organizers. I am Virendra and I'm currently a law student pursuing my BLLB with honors in criminal laws. Today I'll be talking about the attribution of accountability under the notion of autonomous weapon systems and why we need to have a shift from individual responsibility towards collective and state responsibility. I'll first begin by describing what is AWS, that is Autonomous Weapon Systems, because currently we have a lot of major powers that includes Russia, US, China, India, France, and Israel who are developing and deploying AWS. But at the same time, quite ironically, we do not have a universally accepted definition of what an AWS exactly is. And this is because of the fact that AWS in itself is not one weapon, it's a variety of weapons which are continuously growing and they're continuously evolving with changing technological circumstances. I've, in my introduction, given various examples of different countries with different definitions. So, for example, UK and France require a human like cognitive ability and autonomy. That means that the weapon must be able to take decisions completely on its own without there being any human present. Now, this requires a very high level of autonomy, and only if a weapon is able to have such a high level of autonomy would it be classified as an AWS, according to the UK and France. At the same time, Russia, US, and China emphasize on the capability to identify and engage targets. They do not consider the taking of cognitive abilities, rather, they focus on whether the weapon, for example, if it's a drone, can it lock targets and can it fire on the targets without there being a human present. So, this is a different definition of autonomous weapon systems, which focuses on task autonomy. Instead of having an overall general intelligence, this is about whether that robot can perform certain tasks or not. And if we talk about an NGO that is Campaign to Stop Killer Robots, which has also been talked about by many of the previous presenters, they also think that if a system is able to detect and strike targets based on the data that is gathered from its sensors, then only is it autonomous. So we can see here that definitions of autonomy are differing between countries and between organizations, and that has led to problems in defining what AWS exactly is. And at the same time, since its use is becoming more and more recent, like for example, just a few days ago, it was in Algeria that a drone was used and it injured many civilians, and it was an AI powered drone. So these issues are no longer the realm of speculation. There is, of course, the chance of accidents and misuse, which endangers civilians, which endangers non-combatants in international humanitarian law. And therefore, the core questions that I've tried to answer in my paper are two. Firstly, who is exactly responsible? Because we've not been able to figure that out yet as an international community. And how do we assign this responsibility? Under what legal mechanism can we have this responsibility? And therefore, the rationale of my paper is to delineate how the AWS is evolving in its use and why we should move towards collective and state responsibility, respectively, rather than focusing on individual liability. Now I'll come on to the second part of my presentation, which deals with the contextualization before I proceed with why we need to have a shift away from individual responsibility. The reason that we're talking about responsibility so much is that AWS is inherently unpredictable in nature. AWS is an autonomous system. It is a subset of a broader category of AI powered systems that would also include devices like Amazon Alexa or Google Echo. It would also include devices like ChatGPT. These are all part of AI driven systems, and AWS as autonomous weapon systems, they use the same technology that many of these AI systems use. So they are a subset of these broader autonomous systems, and all of these systems exhibit various degrees of unpredictability. And here we have to talk about two terms. I've mentioned them in the presentation as well. The first is operational autonomy. That is, of course, the ability to be able to do a task. For example, if it's a missile and it has been asked to destroy an enemy bunker, it is the job of the missile to first locate that bunker and then strike that bunker without there being any human present. Now, because there is this operational autonomy in its functioning, the path and the outcome of such operational autonomy can never be directly predicted by the developers. Developers do not know ultimately how the AI will target, which bunker will it choose, and how will it fire the missiles towards that bunker, because that is not in the hands of the developers. That is something that the AI does as in the real time and based on the environment that it sees. And because of that, one of the most important challenges is its susceptibility to adversarial manipulation. Yesterday, while the speakers were talking about various aspects of AWS, another problem was highlighted by one of the speakers, that at many times there are jamming signals that are employed by enemies which can jam these AI drones, and then those drones come in the control of enemy forces. So this is something that is one of the major challenges because of the fact that they are not powered by humans. So the time that it takes for a person to know that their drone has been hijacked is also going to be much larger because they are not in the control of the drone. And at the same time, because of the rapid automated decision making, there is enhanced complexity. Because of the increasing complexity, it is not possible to anticipate what decisions the AWS will take, because unlike a human soldier who takes on the commands of his superior and we know how he's going to perform in a specific circumstance, AWS does not depend on certain commands. It only has the objectives feed it to it. It is not told how to get to those objectives, that it decides on its own. And therefore, in battlefields where everything is changing continuously, where we use the term the fog of war to describe the fact that enemy forces and friendly forces are continuously moving. Different civilians and non-combatants are also present in the midst. And therefore, what we see is a very changing environment. And because of that, the decisions of the AI are also constantly changing, which makes it inherently unpredictable. And because of that, accidents are liable to occur. And when accidents occur, a legal responsibility has to be attributed under the framework of international humanitarian law, which brings me to the main part of the uh, paper that I'm going to highlight, is why we need to move away from individual responsibility while we talk about accountability for AWS. Because traditionally, what we see is that international law is foregrounded in individual liability. Like I've highlighted two examples on the presentation. If a person commits a crime of genocide, they're individually liable under the Genocide Convention. And if they commit a crime of humanity, that is the crimes against humanity, they're liable under the Rome Statute. This is individual liability. A person will be liable in their own capacity, even if it's a group of people who have committed the genocide. Each and every one of those people will be individually liable and not as a group. And many advocates are saying that we should extend this model to AWS violations as well. But I do not agree with the decision to emphasize on individual responsibility because of many reasons. One of the most important reasons is that any war crime requires intent. For that matter, any crime requires intent, which is known as mens rea. Unless you have the knowledge and the express intention to do a crime, it would not be categorized as a crime regardless of the actus reus, that the action that has taken place. And when we talk about AWS, it's not one person who's responsible. It is the programmer who has designed the AI. It is the manufacturer who has actually built the AI. It is the commander who has given the objective to the AI. And it is also the state who is operating the AI, under whose development and under whose leadership the AI is ultimately operating. All of these people together are contributing to the ultimate functioning of the AI. And because of that, the identification of a single responsible party is very difficult. And this is something that is known as the many hands problem. Scholars like J. Galliot have described this problem in great detail in their works, which talks about the fact that because of this many hands, it's very difficult to be able to ascribe liability individually. And the principle of command responsibility is also something that we see in international humanitarian law, where a commander is responsible for the acts of his soldiers if he had the knowledge. But could we use that principle here because of the fact that machines do not tell their commanders when they're going to act, how they're going to act? So would it be wise to hold that individual commander responsible? And at the same time, because of this difficulty in ascribing individual liability, there is no one to compensate the victims. There's no redressal for the victims. There's no restitution for the victims, because identifying the perpetrator itself is a very complicated and tedious process. And by the time, restitution for the victim is no longer possible. And therefore, I proposed two accountability solutions. The first is collective responsibility. Now, before I proceed with defining what collective responsibility is, we are well aware of the just war theory, which mandates that certain moral principles need to be followed. And that is something that AWS also is required to follow because it's a stakeholder in the international humanitarian law. And at the same time, just war theory also has associated principles with it, which is distinction, that you must be able to distinguish between non-combatants and combatants so as to not harm any non-combatants. Those are civilians. That is also codified under Article 48 and 52 of the Additional Protocol to the Geneva Conventions of 1948. We also have the principle of proportionality, that we should only use the bare minimum force that is necessary in order to achieve the intended object and to gather the anticipated military advantage. This is codified under Article 51 of the Additional Protocol to the Geneva Conventions. And if we talk about individual liability, as I've already stated, it becomes very difficult to know whether this distinction and proportionality has been followed by AWS or not. And because of that, collective responsibility is a more grounded solution here, because collective responsibility, as the word states, will make the military personnel, that is all the commanders as well as the institutions. This includes the manufacturing company, the programming company, the software developers. All of them will share liability for any misconduct. And when we talk about shared liability, they all will be proportionally liable. Rather than trying to choose which of them is liable, one of the principles is to hold them all liable. And why is this a valid principle? Because of many of the advantages that I've been able to identify. One of them is, of course, the victims and affected communities. It'll be more easier for them to be able to seek redressal because they can identify the people who have actually committed the harm. And because of the lack of absence of a responsible party in the other scenario, in the case of individual accountability, healing and redressal is something that is very obstructed. And if we talk about the deterrence effect of collective responsibility, this parties would be more careful while they're using AWS. They'll be more careful and adhere to just war, distinction, and proportionality principles. And they will also remember the fact that war is transitory and they can be held accountable if they do not develop their AWS in a manner that is ethically and legally responsible. That is collective responsibility. Another solution that I've tried to propose is state responsibility under ARISWA. ARISWA is the acronym for the Articles on the Responsibility of States for Internationally Wrongful Acts. This is a convention that has been developed by the International Law Commission in 2001. It is not a traditional convention, that is, it has not had any signatories to it, rather it forms part of customary international law, and because of that it is binding on all parties of the UN system, regardless of the fact whether they adhere to it or not, because it's customary law. And if we talk about the term wrongful act here, wrongful act has two requirements under Article 2 of this convention, is that the act or omission must be attributable to the state. That is, it is something that the state must have done. And secondly, there must have been a breach of an international obligation by the state as a result of this act or omission. And if we talk about the first requirement, it for what acts or omissions would be the state responsible? So the answer to this is given in Articles 4 and 5 of this convention. Article 4 states that actions of any state organs, which includes your military as well as any intelligence agencies, would be state acts. And Article 5 goes further to state that even non-state actors who are authorized to exercise government functions, like for example, if the government is delegating some of its functions in terms of AWS, that is the programming and the development of AWS, to private software companies. So that is also something that forms as a state action. And because of this reason, any actions of AWS would also lead to the state being responsible for those. And the second requirement, of course, is when the act or omission leads to a breach. This is where there is significant dispute amongst the scholars. I have highlighted two scholars, Marco Sassoli and Pascal Nagler. They are one of the leading figures in the question of when the act or omission leads to a breach. They state that violation or breach will occur at the instant the unlawful act takes place. So rather than waiting for the war to be over, when for example, if the machine kills a civilian,
I think you have done with your presentation. Now,
I'll just take 2 minutes to just cover up. I am very sorry. Yeah, just 2 minutes. I'll finish. Okay, thank you. Okay. As I was saying, the violation or breach would take place at the moment the unlawful act takes place. And ARISVA also recognizes accountability for multiple states. So, for example, if 2 or more countries are acting together, if they have the knowledge that they're going to commit certain unlawful acts, then also they can be held liable. I've also highlighted 3 additional suggestions for strengthening state responsibility. The first one is that we should have a legally binding treaty on AWS, and we can incorporate war torts in this treaty. Now, war torts is something that scholars like Rebecca Krutoff define as serious and humanitarian law breaches which trigger state liability. This is not criminal liability, this is tortious liability by the state. So this would lead to reparations for the victims and it would deter future misconduct. My second suggestion is to expand the scope of Article 4 of the ARISVA so that we can actually include AI-driven actions within the expansion of the ARISVA rather than we having to go to other statutes or other treaties to hold the perpetrators liable. And lastly, we can also incorporate the strict liability standard while we're dealing with legal responsibility. As we know that strict liability means if a person is responsible for anything, they will be responsible regardless of whether they had the intention to do it or not. So in terms of AWS, the state would be responsible as long as they knew that this AWS had the capacity to cause harm and they still allowed it to be deployed. And I'll conclude here that because individual liability is impractical, we need to have a greater emphasis on collective liability as well as state responsibility. These are two solutions. We can have them concurrently so that we are able to give redressal to the victims as well as to cause deterrence so that better AWS systems can be developed. And in the future, interdisciplinary collaboration is necessary in these circumstances because this is not only a legal issue, this is also a policy issue and this is a technical issue. So legal scholars as well as AI experts and policy makers and technical experts need to work together. Thank you. That is my presentation. This is the references that I've used. You can go through them if you wish to. Thank you so much.
Thank you so much. Now we shall revert with back with the presentation of Dr. Lakshmi. Ma'am, could you try now?
Audible, sir?
Yes, now you are audible. You're much
Thank you.
clear, visible.
Can I
Yes.
share my PPT?
Yes, you can share. Yes, please. You see the bottom of the page, there is a share.
Is it visible?
Yes, visible. Yes, you may proceed.
I'm Dr. C.H. Lakshmi, Assistant Professor from Damodam Samjeev National Law University, Visakhapatnam.
Ma'am, again, you're not audible. Yes, ma'am. Your voice is low. A little increase your volume. Yes. Now there is a audio issue, ma'am. If I'm not audible, it's not a problem, but what about the audience? Ma'am, you're on mute. Just let me see if I can help you. Dr. Lakshmi. Just a minute, ma'am. Ma'am, you're not audible. You try now? Yes, your voice is very weak. We cannot hear. It is not clearly audible. Ma'am, we are very much interested to hear you, but it is a technical issue. Probably we will try for the next time again. Okay, we shall move again. You try to make the technical issue. We will revert back to you, right? Yes, we have next presenters, Abhinisha Jayakumar. She will be presenting her topic on the role of international humanitarian law in addressing algorithm biases in humanitarian aid delivery. Abhinisha, we invite you to take the virtual stage. You may. Yes, let me make you visible. You are visible there on the screen, but
Sir, am I audible?
yes, you're audible. You please proceed.
Yes, sir. I would like to share my screen, sir. Wait a
Yes.
moment. Sir, is it visible?
Yes, you can proceed.
Yes, sir. Thanks, sir. Good morning, participants, respected panelists, and organizers. It is my privilege to present on the role of international humanitarian law in addressing the algorithmic bias in humanitarian aid delivery during this two-day international webinar on artificial intelligence and AI principles. Artificial intelligence is transforming various domains, including humanitarian aid, military operations. While it offers a great promise,
Ma'am, we're not, your
it also
screen is not visible. Abhinisha, your screen is not visible. Could you share? You have shared the PPT.
Yes, sir. Yes, sir.
Is it visible to
Not
audience?
visible.
Not visible. I think I.
Wait a second. It's not moving.
Yes, you try. You close once again.
Yes,
and
sir.
share. Yes. Can you share now?
Yes, sir.
Yes, please share.
Visible, sir?
Can you double click? If you double click, it will show us. Yes, now you can proceed.
Yes, sir.
Yes,
Thank
yes.
you, sir.
Yes.
Yes. So, focusing on that, as we heard from all the presenters, accountability is the central theme in the discussion of the intersection of law, technology, and humanitarian effort. In line with this, my research titled the role of international humanitarian law in addressing algorithm bias in humanitarian aid delivery aims to delve into how accountability is affected by increased use of artificial intelligence in humanitarian contexts. So, as the opening quote, the advent of AI in war form challenges not to abandon our humanity, but to reaffirm it through the law and ethics. Today, I will explore how international humanitarian law provides a robust framework to address these challenges, ensuring that AI systems are transparent, accountable, and aligned with the humanitarian values. So, to set a stage, let us delve into the context, problem statement, and the objective of this discussion. So, the use of AI in the military operations, particularly in the targeting system, has gained traction in recent years. These technologies promise greater precision and efficiency in decision making, but they are also prone to ethical operational pitfalls such as bias, opacity, and misuse. So, algorithmic bias directly conflict with the key principles of IHL, such as proportionality, distinction, and humanities. So these conflicts undermine the ethical and legal foundation of humanitarian efforts. For instance, biased AI systems may misclassify civilians as components, leading to unnecessary suffering, a violation of IHL. And the goal of this presentation is to explore how IHL principles can address these challenges, offering solutions to align with AI systems with humanitarian principles and mitigate the risk they pose. Through this lens, let's move on to the research questions that frame our exploration. So, IHL principles provide a framework to address algorithmic bias, but there are significant challenges to operationalizing these principles in AI systems. So, this brings us three key research questions, like how does IHL ensure fairness and prevent discrimination in algorithmic targeting? Bias in AI systems is marginalizing while the IHL principles of impartiality. And can the principles of proportionality and distinctions be effectively applied to the AI systems? And these principles ensure that civilians are protected, but AI systems often struggle with accurate classification. And what lessons from early technologies such as cyber war can inform AI regulations? So historical precedents show us how IHL adapts to emerging technologies. As we examine these questions, we will see how IHL principal foundations are key to regulating AI in humanitarian and military contexts. And moving on to the IHL principles in focus, IHL as a legal framework is rooted in ethical principles that govern behavior during armed conflict. Let us focus on 4 key principles particularly relevant to AI regulations. Principle of humanity. This principle emphasizes the importance of minimizing suffering and respecting human dignity. AI systems, however, may unintentionally exacerbate harm due to algorithmic errors or bias. And principle of distinctions. So central to IHL, this principle requires differentiating between components and civilians. AI systems often misclassify individuals, leading to violation of this principle, causing significant harm. And proportionality ensures that the military advantage is balanced against the potential civilian harms. And biased or flawed AI systems can disproportionately harm civilian populations, undermining these principles. And the main most thing is accountability. The IHL demands mechanism to rectify harm caused by violations. For AI, this requires transparency and explainability so that decision can be reviewed and challenged when errors occur. As Jean Maris wisely observed, in times of armed conflicts, our responsibility is not just to win, but to do so with losing the sight of what makes us human values. IHL principles provide a moral and legal compass to regulate AI. However, challenges remain in aligned with this principle with AI operation realities. Yes. So let us now turn into the primary challenges AI presents in the humanitarian and military context. First and foremost is algorithmic bias. AI systems often rely on data sets that reflect historical or systematic bias, and this can lead to unequitable outcomes such as misclassifying compounds or disproportionately targeting vulnerable populations and opacity in decision making. AI operates as a black box while bad decision making processes are not easily understood, and this lack of transparency complicates accountability, a cornerstone of IHL, and the dual use of dilemma, which is AI technology designed for humanitarian purpose, such as disaster management tools, can be adopted for military use also. So this dual use potential raises ethical concerns and complicate compliance with IHL. So these challenges demand a robust framework integrate IHL principles into AI development and deployments. So to understand the real world implication of algorithmic bias, let's examine 3 case studies. First is targeting system in military operations. So machine learning models have misclassified civilians as combat, which I've already said, leading to violation of the principle of distinctions. And mass grave identifications Mexico. So, which is AI errors is analyzing biased data sets cause critical oversight in identifying mass graves, undermining the justice efforts. And the judicial predictions in the European Court of Human Rights. AI systems influence legal decisions, tweaking outcomes and compromising the right to fair trial, which is also a fundamental principle of IHS. So these examples illustrate how bias in AI systems can devastating consequence, emphasizing the need of proactive regulations. And history provides a valuable lessons on reflecting emerging technologies. Drones, the principle of proportionality was adapted to drones, ensuring that use was minimized harm while maximizing advantages. The conflicts highlighted the importance of transparency and accountability principles directly applicable to AI, like cyber war implications. So these experiences demonstrate that IHL is adaptable and can be extended to address the challenge posed by AI. So moving on to the recommendations, now let's turn into the recommendations, practical steps to ensure AI systems align with the principle of international humanitarian law. So to begin with, we need to prioritize deployment of AI system aligned with ISL principle. This means embedding fairness, impartiality, and accountability into the design of these systems from the very start. It is crucial that AI systems are not only effective but also uphold humanitarian values, ensuring that their use do not perpetrate harms. Yes, and the next is transparency and explainability are non-negotiable. AI systems often operate as black space where decisions are made without clear reasoning. To counter this, we must make transparency and explainability mandatory. Every AI decision-making process should be auditable and understandable. This ensures accountability and builds trust in systems we rely on. Furthermore, the establishment of international framework for AI regulation is essential. By harmonizing IHL with AI ethics, we can create global standards that have consistency and clarity. And such a framework would ensure that all nations and organizations deploying AI systems operate within the boundaries of ethical and humanitarian principles, regardless of the context or location. So, in addition, independent oversight is critical. I propose conducting independent audit for AI systems to identify and address bias in the algorithms and data sets. So these third-party reviews would not only enhance the integrity of AI system, but also help mitigate potential harm before it occurs. And lastly, collaboration is the key. We need to focus on capacity building and fostering partnerships and sharing knowledge. By working together, these stakeholders can ensure that AI systems are designed with the deep understanding of ethical implications, and training program and collaborative initiative can strengthen alignment between technology and humanitarian principles. So, in conclusion,
Yes. Is there any question?
so
concerning your
artificial
initial
intelligence.
presentation? Ma'am, you have done with your time. You are
Yes, sir.
exhausted. Yeah, I'm looking
I'd like to
for a
conclude.
question from the audience.
Yes.
Is there any question concerning that presentation? So seeing none, we shall move back. We revert to Dr. Lakshmi. Ma'am, I hope that this time you will be visible. Audible. Again, we cannot hear you, ma'am.
Please unmute yourself, madam. But we are unable to hear.
It's not coming. आवाज नहीं आ रहा है. Ma'am, we are not hearing you. Yes, you're not audible. Can you mute and unmute? Right. So I think there is a technical issue, ma'am. Because of the time constraint, we shall move to the next one. We will consider your paper at the last. We give you once again a chance. So this will be the third time. That is, you have arrived. The fourth one I will have a privilege to give you, but that will be at the last we see. I'm looking for Mr. Imran Akhtar and Nazifullah Niazi. Are you there to present your paper? Right. So we're looking for Zabiullah Shinwari. These are from Afghanistan, has to be here. I don't know. Dr. Lakshmi, ma'am, would you like to present your paper? Let's see, once again, we give you a chance to try. Right.
Sir, I left the meeting and joined right now.
Yes, now you're audible. Yes, ma'am, you can proceed.
The last 2 times I did not do it. Now I left the meeting and joined again. Okay?
Yes, now you can proceed, ma'am. You can proceed.
Am I clear? Am I clear?
Yes, you can go. You proceed, ma'am.
Okay, thank you. I'm sharing the PPT first.
Yes, please do that. Double click on your PPT so that you. Yes.
I think it is visible. It's visible, right?
Yes, you can go ahead. Right.
I think now the time is afternoon. Very good afternoon to everyone.
Yes, good afternoon.
Sorry for giving inconvenience from my side.
It is a technical issue, ma'am.
It's my privilege to present my paper in this occasion. And first of all, let me congratulate you all, the entire team, who took really wonderful responsibility, because this is very much required as per the present scenario. And I am presenting my paper on usage of artificial intelligence and machine learning in military operations and state responsibility. I'm Dr. C.H. Lakshmi, Assistant Professor, Damodaram Sanjeevaya National Law University. And in my paper, I concentrated on mainly 3 aspects. That is how, because in the introduction part, I discussed how the traditional warfare and how the advent of the technology changed the entire shape of military operations. And then the usage of, because the topic itself is the usage of international usage of artificial intelligence in military operations. And accordingly, I started with that, the usage of artificial intelligence, what are the main uses of artificial intelligence in warfare. And then I discussed with the IHL principle, and means in what way
AI is related to IHL principles and then state responsibility, because these are all the key elements which I stressed in my paper. And then coming to, because the earlier speakers and already discussed about the state responsibility as well. And since yesterday, we are hearing about these principles, humanitarian law principles, that are the four fundamental principles. Actually, these are all the three principles: principles of proportionality and military necessity and distinction. These are all we are hearing continuously. But here I am talking about, because earlier papers and speakers are also spoke on jus ad bellum, and jus in bello. But when we talk about the ad bellum, jus ad bellum, that is the first stage of war, because these are all the concepts of just war theory. And but just in bello is appropriate principle he applies with related to international humanitarian law, because this is a fundamental norm to IHL. And coming to the earlier wars and the present wars, because after two world wars, how the United Nations was established, we all know. If you look at the preamble part of the United Nations Charter, there, we the peoples of the United Nations, actually, why they established the state to save the succeeding generations from the scourge of warfare. So that is the concept of the 1945s or 50s. No more war. But now the scenario has been completely changed. Now you can find, after, because 1949 Geneva Conventions were adopted, we all know. In 1977, the latter it was developed into additional protocols were added. But from there onwards, now we are in 2024, we are talking about all the fundamental principles of IHL. Is it really necessary to discuss about this? Because these are already, we can say this is an peremptory norm of the international law, because states already accepted, and they wanted to save the succeeding generations from the future of warfare, and they don't want to go for any wars in future. That is the peremptory norm of it. So you can say jus in bello is in fact it is said to be the peremptory norm of international humanity. That is a just cogence, we can say. But now we can say how the present wars is you can say Israel, Palestine, and Ukraine, Russia. These are on the first after 2000s. There are many wars in Sudan, and these are all affected. And especially principle of humanity is not at all followed at any circumstances. But coming to AI, now this is the important element with reference to this webinar. We know how AI has been complete, because the technological advancement impact is very severe in all operations, including military operations. But one way we have to appreciate this technological advancement. The reason is, one way it actually provides numerous benefits. Because if warfare, we know how the warfare is severely impacted on human beings and human suffering, even directly or indirectly also. Civilians may be affected. That was the reason Geneva Conventions, all four Geneva Conventions were adopted. We know that. But coming to this AI, if you observe the various usages, for example, in case of warfare, there is a possibility to identify targets with reference to AI. That would be very useful to any state parties, and at the same time, they can mitigate the effects of warfare. Undoubtedly, because what the additional protocol 1, especially I think part 2, that is means Article 35 onwards, you can observe state parties do not have any unlimited methods or means of warfare. There is a limit, but that limit is subject to usage of weapons. If it causes any unnecessary suffering or superfluous injury, that means and methods of warfare not to be adopted. But anyway, with the development of the technology, it is very required. It is very much required. It is inevitable by the state parties. They can use it, because by using the AI, they can follow the principles of humanitarian law. how it could be that we can understand with reference to this, we can minimize the human suffering and we can alleviate the human suffering, which is the fundamental, which is a main aim of the international humanitarian at the time of the 1864. How they, by the time when the Henry Junant proposed these two proposals before the Swiss government. So with that, we can actually states can easily observe that main targets, and at the same time it can promote the efficiency of military operations also, and it can actually minimize the human intervention, especially on the battlefield. And many researchers and through the various journals and through the various states authorities, states headmen also spoke that the future wars. I heard it. I read this one in 2016 or 17. Future wars maybe unmanned arms, unmanned arms and unmanned wars. Yes, it's true. Even after now, there is a human intervention is there with reference to artificial intelligence. In future, it may not be possible. We can see the completely unmanned war only. So AI can apply, AI can improve the military operations, military efficiency, and now you can observe. Even I think because in yesterday's paper, I think Miss Anastasia, she spoke about Ukraine, how Ukraine used this artificial intelligence to alleviate human suffering, especially that drone swarms. This could be useful to actually follow, to apply the principles of humanitarian law. So this is also inevitable for every state. They can go ahead and undoubtedly. And cyber security, we know nowadays cyber warfare is also there, but unfortunately, except standard manual, there was no specific international consensus on cyber law, cyber warfare. And earlier speakers and in morning also I observed with reference to the aerospace. They said all the international humanitarian law principles applies to irrespective of the nature of warfare. Either it is a cyber warfare, either it is and artificial intelligence or warfare, or it is a naval warfare, whatever it might be, whatnot. These Geneva Conventions and national protocols applies to every warfare. And in addition to that, one of the fundamental principles, that is a principle of humanity, that is especially to provide their services, especially to sick and wounded people. By the time, it would be very difficult. That is your main obstacle. Actually, principle of humanity is not actually followed in the warfare, any case of warfare. But with reference to AI applications, they can, this is the second point I mentioned, AI applications in humanitarian efforts is definitely shield the armed conflict victims. But how it would be? That is, they can immediately, even they cannot take the decisions, but they can pointed out the specific hospital zones, and accordingly they can ship that wounded and sick people of victims from one place to another. And another thing is, in yesterday's Srinivas sir, he also stated that now machine learning is a well advanced stage of AI. So it can actually that human consensus, human concern, these are all bestowed to the present day of artificial intelligence. So accordingly, they can now artificial intelligence, by using the artificial intelligence, we can also follow the principles of international humanitarian. That's the thing we can observe in the present days and future days, because as my earlier speaker said, artificial intelligence is not static. From electronical signals to artificial intelligence, in that way the warfare is going. And moreover, these drone swarms, they were used by the Ukraine especially to mitigate the effects of electronic warfare, which is which has been used by the Russia. But coming to these,
Ma'am, again, we're not able to hear you. Thank you so much. You have done with your presentation. Whatever you had, you have given the gist of it. So we shall move to the next presenter. Our next presenter is Dr. Monica Jain, Assistant Professor, MEMS, along with Mr. Ketan Singh, BLLB first year, who will present on the intricacies of the same military AI and with the international humanitarian law. I want to hear something from the Dr. Jain.
Hello, sir. Am I audible?
Yes, you have done, ma'am. Thank you. Thank you so much. Now you're audible. We lost your voice. That's why we leave you. Thank you so much, ma'am. You have done.
Am I audible, sir?
Yes, you are audible.
So I will start, yes.
Where is your, I believe so, you are the co-author. Where is your author?
I am going to present, sir, in this.
Oh, you are going to present, but this is a joint paper. When you are seeking credit, both of you should be present, no? If she is absent, then I'll send certificate to you, not to her. Is it fine? I'll mark you here. I'll send the certificate for you, not to her. Then you can present. Please proceed. You will do your part. Either both or one.
So will you give me 5 minutes?
It is a joint contribution, right?
Yes, sir. Will you give me 5 minutes? I will just come back.
Or you're going to come back. So we shall move to the next presenter till you come back, right?
Okay, thank you, sir, so much.
Yes. Okay, we shall move to Miss Patience. She's from Kenya. Are you there, ma'am?
I have a bit of a technical issue. Can I come back in 5 also?
Yeah, you want to come also in 5 minutes.
Yeah.
Okay, we shall go to the next. Anna Bashir. Miss Anna Bashir. Are you here? I've seen you. You've joined, but I don't know where are you right now. So following Bashir's, she's not here. We have the next presenter, Sharana Basia from Bangalore University Law Department. Seeing none. So, Mr. Rakesh Kumar Sharma, are you there? Right. I'm looking for Mr. Muhammad Imran Ali from Quaid Azam Law College, Pakistan. Mr. Muhammad Imran Ali. Actually, this presentation would have been in the afternoon session, I mean, after lunch, since a couple of presenters are absent, so it is proposed. What about Ms. Najma Nusha? Nushat is also absent. I'm looking next for Ananya. Ananya is also absent. Okay, Dr. Gary, but she has sent me a message. She's in hospital. Martina Jacob from Kerala. Martina Jacob, you are not available. The next presenter, Mama Subhan from JSS Law College. Then followed by Miss Jyoti Mitokshi. Smriti from the Department of Studies in Law, University of Mysore. Are you ready? I think you have joined. Smriti, you are ready to present your paper?
Hello, sir. Am I audible?
Yes, you are audible. Are you ready to present your paper?
Is it now or in the afternoon session, sir?
Now you can present because a couple of presenters are absent. If you wish to present, you can.
Sure, sir. Can I please get 2 minutes of time? I will just get my paper. It's here.
So everyone asking
in
2
the
minutes.
afternoon, so I will get back to you.
2 minutes after
Yes, sir.
you.
Yes, sir.
I think I should go back.
Yes, sir.
Right. So I'm looking for the Dr. Jain, Dr. Monica Jain.
Yes, sir.
Yes, you.
Sir,
Yes.
yes, she is busy in university and evaluation work, so
Okay,
she.
you start to do your presentation. You will do part of your work. We will
Okay, sir.
see. Yes.
Okay, sir. So good afternoon, everyone. It's a great honor and privilege to here today. On behalf of Maharaja Agresti Institute of Management Studies, New Delhi, I would like to extend a heartfelt gratitude to the organizers for organizing this insightful and enriching seminar and the meticulous planning.
You have joined from New Delhi.
Sir, sorry, sir.
You have joined from New Delhi.
Yes, sir.
Okay, right. Continue.
My name is Ketan Singh, and I'm a first year BLLB student with a deep curiosity about the intersections of artificial intelligence, law, and humanity. Today, we are venturing into a fascinating yet complex realm, the interplay between the military artificial intelligence and the international humanitarian law. As we navigate this topic, we will uncover how cutting edge technology challenges age old principles of warfare and justice, raising questions that are urgent as they are profound. The research paper discusses the intricacies of using military artificial intelligence and its implications for international humanitarian law. It highlights the growing integration of AI into military operations and the associated opportunities and challenges. So, there are the valuable key points under the research paper. The first is that AI has transformed modern warfare, enabling enhanced efficiency, productivity, and safety compared to conventional human methods. However, it also raises serious ethical and legal concerns. The military use of AI must comply with existing IHL principles such as distinction, proportionality, and precautions. Challenges arise when AI systems make decisions that could breach the laws of war. Establishing accountability and responsibility for AI-driven violations of IHL is a crucial issue as the hierarchical nature of armed forces and the lack of moral agency in AI systems make it difficult to determine the liability. Developing a new legal framework to regulate the use of AI in armed conflict is necessary to ensure adherence to the IHL and protect human life and safety. So there are two important questions that arise from the discussions. That is, first, what are the key principles of international humanitarian law that are relevant to the development and use of autonomous weapon systems? The key principles are the distinction. The autonomous weapon systems must be able to distinguish between the combatants and the civilians, as well as between combatants who are actively engaged in battle and, for example, those who are expressing a desire to surrender or who are ill or injured, as well as between military and civilian targets, and as a result, to limit strikes to military targets. Attacking a civilian population or individual civilians is forbidden by the principles of distinction under the international humanitarian law. The second principle is the proportionality. The use of autonomous weapon systems must adhere to the principle of proportionality, meaning that the expected collateral damage to civilians and civilian objects must not be excessive in relation to the anticipated military advantage. The third principle is of precaution. Those deploying autonomous weapon systems must take all feasible precautions to avoid and in any event minimize incidental loss of civilian life, injury to civilians, and damage to civilian objects. The last principle is of accountability and responsibility. There must be a clear accountability and responsibility for the development and deployment and use of autonomous weapon systems to ensure compliance with international humanitarian law. These principles are essential for regulating the development and use of autonomous weapon systems to ensure that they comply with IHL and minimize harm to civilians. The second question, the pertinent question that arises from the research paper is that how case studies from the conflicts like the Israel-Palestine conflict and the Russia-Ukraine war demonstrated the challenges in using AI-powered military technologies while complying with the international humanitarian law. The international community has clearly seen case studies like the Israel-Palestine conflict and the Russia-Ukraine war, which demonstrates how prudent we need to be in using AI technology in warfare to prevent civilian casualties and collateral damage. For instance, the Cuban Missile Crisis of the Cold War, which almost led to the nuclear conflict, exemplifies the crucial importance of autonomous weapon systems.
Yes.
Sorry, sir.
Yes. Is there any problem?
No, sir. I'll continue. Though the international humanitarian community has clearly seen case studies like the Israel-Palestine conflict and the Russia-Ukraine war, which demonstrates how prudent we need to be in using AI technology in warfare to prevent civilian casualties and collateral damage. For instance, the Cuban Missile Crisis of the Cold War, which almost led to a nuclear conflict, exemplifies the crucial importance of autonomous weapon systems and target recognition. These case studies have demonstrated the challenges in using AI-powered military technologies while complying with international humanitarian law in several ways, like the distinction and proportionality. AI-powered weapons and targeting systems raise concerns about the ability to distinguish between the combatants and the civilians, as well as the proportionality of attacks to minimize civilian casualties and the collateral damage. Accountability and responsibility. The hierarchical nature of armed forces and the lack of moral agency in AI systems make it challenging to determine liability and accountability for violations of IHL committed by AI-driven military technologies. The use of AI in warfare presents difficult ethical issues such as responsibility and transparency. Even though technology has the potential to improve military capabilities and efficiency, the lack of human judgment in AI systems can lead to decisions that breach the laws of war. So, by these principles and instances, there's a need for a new legal framework by establishing clear legal frameworks, enhancing human oversight, conducting rigorous testing, promoting transparency, and fostering international cooperation. States can work towards ensuring that the use of AI in military operations complies with IHL and protects civilian lives. In summary, the case studies demonstrates the complexities and ethical dilemmas associated with integrating AI into military operations while upholding IHL standards. The responsible development and application of military AI are essential for maintaining the integrity of international humanitarian law in era of rapid technological advancements. In closing, the intersection of military AI and international humanitarian law represents both a challenge and an opportunity. As technology rapidly evolves, the complexities of ensuring compliance with humanitarian principles grow ever more intricate. Yet, this very challenge calls for a global collaboration, ethical foresight, and unwavering commitment to human dignity. The road ahead demands balance, balancing innovation with accountability, security with humanity, and progress with justice. As we navigate these uncharted territories, let us remember that our actions today will define the ethical framework for generations to come. Thank you.
Thank you so much for your presentation. We are looking for Smriti. Are you there?
Yes, sir. Am I audible?
Yes, you're audible.
Yes, sir. Can I go ahead with my presentation?
Yes, you can go.
A very good afternoon to one and all present here, respected sir and my dear friends. Today, I am before you in this webinar to present my views on an analysis of the challenges and the international legal framework on the responsibility of the state for the usage of autonomous weapon system. Now, one of the speakers in the previous sessions, they highlighted about the movie called Terminator. So as soon as I heard about this autonomous weapon system, I being a South Indian, immediately my memory flashed back to a movie called Endiran the Robot, wherein the robot there, Chitty, failed in its a military test because it failed to recognize human emotions over there. So in the era of rapid advancement of science and technology, there is a greed between nations to produce and procure more sophisticated weapons, arms, and ammunitions. So investments are also being made in this particular field, and this has become one of the greatest challenges before international humanitarian law. Now, to begin with, this AWS, that is the autonomous weapon system, are also called as killer robots, and we all by this time know that they are powered and programmed by artificial intelligence. The challenge that is before international humanitarian law today is about not only in the development of this autonomous weapon system, but also in their regulation and in their enforcement. And just in case they enforce it in an unlawful way, how can they be held accountable or responsible? In this regard, I have tried to analyze the existing legal framework, though there isn't proper legal framework to govern the AWS systems. Can the usage of AWS systems in the immediate future, can the states be held responsible is the challenge that I've tried to analyze throughout this paper. So we all understand that the law of state responsibility is one of the fundamental underlying principles of international law. And the central idea here being, if a state commits an internationally unlawful act, it has to bear international responsibility, and the responsibility immediately arises between two states. Now, the entire framework of this state responsibility is under the umbrella of the RCIVA, that is the draft articles for the internationally wrongful acts committed by states. Now, the entire crux of this RCIVA can be analyzed under Article 1, which states that when a state commits any internationally wrongful act, it automatically entails it a responsibility. Now, the responsibility here is a duty to make reparation. But here, the question is, if the AWS system takes lives, can the lives be monetarily compensated? So, if such was being used unlawfully. Now, Article 2 of this RCIVA highlights the elements of an internationally wrongful act of a state. Now, throughout my paper, I have tried to analyze these characteristics and how the AWS weapon system can be held accountable in the absence of a particular established framework governing the regulation of AWS. Now, the first essential characteristic is there has to be a breach of an international obligation, either arising from a treaty or a non-treaty. And the second and the third is the issue of attribution. And thirdly, it is about the reparation and the compensation. Now, we all understand that for a state responsibility to arise, there has to be a breach of an international obligation. Now, the Common Article 1 to the 1949 Geneva Conventions require the state parties to respect and ensure respect for all the conventions under all circumstances. Here, there is both a positive and a negative obligation which is being shouldered on states. That first, they have to respect. And secondly, they have to ensure that the others are also respecting this particular convention relating to international humanitarian law. So when there are two major laws governing the weapons framework. One is the weapons law, which deals about how a weapon and its means or methods can be used lawfully. Secondly, it's the targeting laws, which states that how what happens when there is any omissions or breach of fundamental principles of international law, international humanitarian law. Now, I would like to analyze here how these international obligations are being violated by the usage of AWS system. First is the principle of distinction. That is, the AWS system are not yet in the present day are in a situation where if they are engaged in combats, they have to be able to distinguish between civilians and the combatants, the active military combatants and the hostile combatants, and the civilian and the military objects, which is under question in this particular issue. So this has also been objected to by the Human Rights Watch. The second one is the proportionality principle, which states that it actually prohibits any conduct or an attack which is expected to cause any loss or injury to civilians, damage civilian objects, or a combination thereof. Thirdly, it is the precautionary principle, wherein it states that they are expected to take constant care and spare civilian population and civilian objects at the time of military operations, and see that only the military objectives are achieved, and if there is any excess in whatever target they have kept in mind, if it's exceeding if it is risking the civilian lives, then they'll have to call out that operation. Now, the question is, can the AWS by itself, without the human control being, cancel the operations because it lacks the emotive quotient that was raised by one of the speakers here? So risk of discrimination and risk of the usage of AWS in other operations are also pertinent questions which also poses challenges before the international humanitarian law. Now, the second element that I will be focusing about is the concept of attribution, wherein how if the question here would be whether the relevant international conventions existing today answer the question of attribution when it comes to the usage of AWS. Now, Article 4, as the previous speakers highlighted, now it mainly deals about the conduct of organs of the state as to who can be held responsible, whether the state itself can be responsible or the persons who are operating under or for the state or as the organs or the agents of the state are to be held responsible. Now, the question here under consideration is whether AWS by itself would actually act as the organ of the state so as to directly attribute it the responsibility for whatever wrongful actions is being committed by it, which results in the breach of international obligations. Now, if the question is answered in affirmative, then for whatever violations is being done by the particular AWS system, it can actually be held responsible and accountable. However, in our case, in the present scenario, AWS by itself would not constitute as the agent or the organ of the state, since it lacks official capacity to act as the agent of the state or on behalf of the state when such is being deployed on the battlefield. So the human conduct is also one of the important factors when we talk about state responsibility. So since the autonomous weapons do operate autonomously, the human conduct, there is an absence of human conduct if it is a completely freely autonomous weapon system. Now, accountability of private parties is also one of the challenge in this particular system, because
You are exhausted with your time.
Sir, I would like to conclude in 2 minutes. I have 2 points left. That is the accountability of private parties and the accountability of other states. I would like to seek 2 minutes of time to conclude.
Please proceed. Yeah.
Yes. So when we come to the accountability of private parties, now Lanson and Turbo, they do manufacture particular equipments and machines for ISRO. Now, in this particular case, they are directly classified to be the actually the agents of the state, because the state itself has given them that responsibility. So if there is any mishap happening or if there is any violation, then the private parties as well as the state can be held responsible. So this is one of my recommendations as well, that if there has to be a tie-up or a linkage, if a private party is being given that responsibility to manufacture AWS, so that even they can be held responsible. Because they include the private parties here, will also include the developers, the manufacturers, the engineers who built that particular AWS system. Then the accountability of other state. Suppose if the X state gives the AWS which they have manufactured to the Y state, knowing under the circumstances if that would be unlawfully operated or used in military operations which are going to breach international obligations, then the attribution would be held. They will be held liable there as well. So in my conclusion, I would like to state that there has to be a robust international framework to govern this particular AWS systems regulation, enforcement, and development. Though RCWA is the current international framework for governing state responsibility, along with customary international humanitarian law and the human rights law, there has to be a particular convention specifically governing the LAWS, that is the Lethal Autonomous Weapon System. The state parties along with should cooperate and coordinate along with international bodies, that is the UN and the ICRC, to tackle this particular challenge. I would like to thank all of you for your patience.
Okay, thank you. Is there any question concerning her presentation?
Yes, sir, there are questions, but it's not for Miss, it's for the University of Mysore.
Yes.
Sir, we attended your last session as well, which was held on 14th December, and we didn't get a certificate for that. I explained everything in my message and chat. If you could just shed some light on that. We attended the webinar on the interplay.
You're addressing in wrong platform. This is a different institution. You can write email there. You have a time. And there is
I did, sir, and I did, and they did not reply. I thought that since you are a representative of University of Mysore, I just should, bring it up to you.
You can write to me. So I'm looking for another presenter.
Sir, I did message you on WhatsApp, and I did not get a reply.
If you understand the language, we are very soft to support you, but we wanted someone who filled the form on time. After a week, we will
I did fill the form on time. It's okay. What has happened has happened. I just, request that I get a certificate for participation on this webinar.
You can write to me or just You can write to me. We will be responding to you. You're wasting others' time. Get lost. Always the Pakistani being rude like this. So we'll go for the next presenter. When we fill we submit the form for the presenters, those who are participating, it's not a single individual. We cannot go according to wish of each individual. So of course, we respect your time. Meantime, we also anticipate some sort of professionalism that you understand our time. Midnight, we cannot issue a certificate to someone, and we cannot go give a certificate to someone who did not attend. So considering that we don't waste now the time, Ms. Passion, did you join?
Yes, I did. Can you
Yes.
see me?
Yeah, we can see you. We would love to see you. Yes.
Thank you, sir. My name is Patience Chipchirchir. I am a fourth year LLB student at Kabarak University, and I'm also an assistant editor at Kabarak Law Review.
Yes, you can proceed.
So my paper is titled A Roadmap to Responsible AI, Exploring Accountability, Ethics, and Regulation in Autonomous Weapon Systems. So first thing you need to note is that autonomous weapon systems are, as Mr. Wayne said yesterday, are conventional means, that they are new, upcoming means that have not seen major regulation around them. So the first thing we need to explore is what is an autonomous weapon system. In the morning, a presenter did give the ICRC's definition that it is a weapon that has autonomy in its critical functions, that it can select, target, attack, and neutralize a target without human intervention. NATO also offers a definition that is along the same lines as the one offered by the ICRC, that this is it is a system that acts to accomplish a desired goal within defined parameters, following an unpredictable course of action due to its situational awareness. That being said, the group of governmental experts on lethal autonomous weapon systems have also grappled with the idea of defining what this is. So what you need to know is that the key problem is the idea of human interaction. So what is adequate human interaction? What is enough to call it human interaction? That is, what is enough to make it meaningful in the meaningful human control debate? So that being said, I'll go to the first problem that is occasioned with the use of such systems, which is autonomy and accountability. So when you think of autonomy, you think of a system that is fully able to carry out its functions without human intervention. This is problematic in the realm of IHL and ICL because we always need someone to go back on, someone who initiated the chain of command for the violation to occur. But as you look at the loops of human control, that is human in the loop, human on the loop, and human out of the loop, there seems to be a disconnect, because if it's a human out of the loop system, then who do we go back to? Because it was a fully autonomous system. We could use a RISWA to say that since the state initiated this, we should hold the state accountable. But what about the manufacturer who created the system, bearing in mind that it lacked the option of intervention? So that's a good question that needs much deliberation. Another problem is normally the ethical considerations that come with the use of such systems, because is it ever right for a system to decide who gets to live and who gets to die? So that being said, Martin's clause is very clear that whenever there is something that can shake the human conscience or the international conscience, then it needs to be revisited. And an autonomous weapon system is one of those things that, as we have seen in the Ukraine-Russian war, and more specifically the Palestine-Israel conflict, that these systems act, and as they act, there are great civilian casualties. And the last bit that is normally problematic when it comes to autonomous weapon systems is the idea of regulation, because Article 36 of Additional Protocol 1 is not as vast, or whenever the drafters were drafting, they did not consider that there would be a system that can work independent of a human. So it might not be as rigorous, the process of benchmarking might not be as rigorous to the autonomous weapon systems as it would be to a system that requires human intervention to work, maybe a kinetic type of weapon. Also, the fact that there is no agreed upon norm, that none of us can agree on what meaningful human control is. None of us can agree on whether we should ban, regulate, or find a way to live harmoniously with this system. So this also creates some sort of disconnect when it comes to regulation. That being said, all of these problems definitely have solutions. So when it comes to autonomy, the idea of meaningful human control, or rather human interaction as it's called by the GTE, is something that has been widely discussed, that there needs to be an adequate human interface interaction, not just pressing a mere button, not using the system as a computational system, but that the human aspect is never lost on the system, because again, the human aspect is very important in ensuring that split-second decision, because war is dynamic, war is not static, war is dynamic. In the fact that war is dynamic, we need to find a way to ensure that split-second decisions can be made regardless of the fact that the weapon is in commission. When it comes to ethical considerations, a presenter here talked about algorithmic bias, and she did it wonderfully, which is another key area when it comes to autonomous weapon systems, that these systems are trained on data sets that sometimes are inherently biased, because I'd like to say autonomous weapons don't know, or rather AI doesn't know right from wrong. It knows values. So values input become norm, even if those values are inherently biased. So when it comes to algorithmic bias, value-sensitive design is really important, because value-sensitive designs takes into consideration all stakeholder interests, that person A considers this, person B considers this, person C considers this. And from all these considerations, it comes up with ways to feed, I'd like to say, good norms into the system. There's no good norm you can feed into the system, but an idea of it, because a system, an AI system doesn't know right from wrong, it knows values. So from those values, it can denote right from wrong. So value-sensitive design can be used to counter first algorithmic bias and deal with these ethical considerations, because it will never be right for a system to take a life, but we can give it safeguards so that if that was an eventuality, we can go back and say A, B, C, D was followed to arrive at D. And lastly, when it comes to regulation, as we had said, there is what we use now are normal, because there is no codified text, because none of us can agree on what meaningful is when it comes to meaningful human control. And none of us can agree on whether we should ban, moderate, or we can live in harmony with these systems. The first thing I would recommend is a working instrument. Not to say we create an entirely new system for autonomous weapon systems, no, but find a way to incorporate them into the current regime, because this was a problem we also faced with the cluster munitions, and that is where the cluster munitions treaty came in and has revolutionized how we look at cluster munitions. So looking at the journey in the cluster munitions treaty might be a good way to find common ground when it comes to autonomous weapon systems. And also considering a two-tier regulatory system. What does two-tier mean? It means that we consider the prohibition and regulation simultaneously, because prohibition and regulation are two different things, but they can work together to ensure that these systems are used in a way that is respectful to the IHL principles that are already set out, to ensure that the just war doctrine is reached. If there are no questions, that was my presentation.
Thank you so much. Is there any questions concerning her presentation? Is there any question concerning her presentation? Seeing none, we shall move to the next presenter. Thank you so much. And I hope that you have received my email with regard to the comments which I have given with to your paper. So please incorporate those changes, then you can write to me.
Thank you.
Yes, right. We are looking for Miss Jyoti Meenakshi. She's there? Right. She's not here. And Miss Anna Bashir? Okay, Rakesh Kumar Sharma. And I would love to leave soon. So if they are absent. Mr. Muhammad Imran Ali. Miss Anjun Jahan. Ananya?
I'm there, sir.
Okay, you can present, ma'am, your paper. You can-
Am I supposed to present right now?
Yes, you can. You can go ahead. Yes.
Okay, okay. Just give me a minute, sir.
Yes, please.
Is my PPT is visible to you, sir?
Yeah, double click. Yes, now it is visible. You can proceed. We would like to see you as well.
Okay, sir.
Please turn on your camera. Yes, now you can proceed.
Jai Hind, everyone. My name is Anjum Jahan, and I am a research scholar in Swami Vivekananda Subharati University, that is in Meerut, Uttar Pradesh. So let us start with my research article, that is Navigating the Intersection of Military AI and the International Humanitarian Law, Challenges and Prosecution Principles. Let's dive into the topic. Let's start with the introduction. The rapid integration of artificial intelligence into military operations present unprecedented challenges for international humanitarian law. However, the integration of military AI within the framework of international humanitarian law is a multifaceted domain that demands careful consideration of both its potential benefits and the significant challenges it poses. The adoption of artificial intelligence in military applications has redefined the dynamics of warfare, offering capabilities like autonomous targeting, predictive analytics, and enhanced decision making. However, these advancements raise critical questions about compliance with international humanitarian law, particularly regarding accountability and the prosecution for potential violations. So let us start with the opportunities, that is reducing human error and enhancing efficiency. One of the most promising aspects of military AI is its potential to reduce human error in critical operation. In traditional warfare, human decisions are prone to fatigue, stress, and bias, all of which can lead to costly mistakes. Artificial intelligence, when designed and deployed effectively, can operate with precision and consistency, mitigating the risk of such errors. Now, what are the challenges which has been faced? Despite its potential, the deployment of military AI raises significant concern, particularly regarding its compliance with international humanitarian law. The autonomous nature of AI systems challenges the fundamental principles that underpin humanitarian law. So the first and foremost challenge is the principle of distinction. The principle of distinction is a cornerstone of IHL, requiring that attacks be directed solely at military objectives and not at civilians or civilian objects. While artificial intelligence system can theoretically enhance distinction, their reliance on algorithm and data raises concern about their reliability in complex and dynamic environments. The second, the principle of proportionality. The principle of proportionality prohibits attacks that cause excessive harms to civilians in relation to anticipated military advantage. Autonomous system, however, may lack the contextual understanding necessary to make nuanced proportionality assessments. Unlike human decision makers, AI systems operate based on predefined algorithm and cannot weigh ethical consideration or interpret the broader implication of their actions. This limitation poses a significant risk as disproportionate harm to civilians could occur due to the rigid and empathetic nature of AI decision making. The principle of necessity. The principle of necessity requires that military action be necessary to achieve a legitimate military objective. Autonomous system, by their very nature, may act beyond human oversight, potentially engaging in action that are not strictly necessary or justified under IHL. The lack of direct human control over such system raises questions about accountability and the ability to ensure compliance with the principle of necessity. Now, what are the legal and ethical challenges which has been faced by AI? The integration of AI into military operations has outpaced the development of corresponding legal and ethical frameworks. Current IHL was not designed with autonomous system in mind, leading to gaps in its application to military AI. For example, existing laws do not clearly define accountability for action taken by autonomous systems. If an AI-powered weapon commits a violation of IHL, it remains unclear whether responsibilities lies with the programmer, the operator, or the military commander, or the state deploying the system. Intent and causation in prosecution. Prosecution under IHL requires providing intent or negligence. However, artificial intelligence systems lack and their action are result of programming and data inputs. This creates challenges in attributing liability. Suppose if an AI system acts unpredictably due to poor programming, should the developer or the operator be prosecuted for negligence? So now I would like to conclude the intersection of the military, AI and IHL present both opportunities and challenges. While AI has the potential to reduce human error and enhance operational efficiency, its autonomous nature poses risk to the fundamental principles of IHL. Addressing these challenges require proactive legal reform, ethical innovation, and global collaboration. By navigating these complexities, the international community can ensure that military AI is used responsibly and lawfully, safeguarding humanity even amidst technological advancement in warfare. Thank you so much.
Thank you, ma'am. Thank you so much for your wonderful presentation and PPT. I was
Thank you,
impressed
sir.
by this. Is there any question concerning her presentation? We're supposed to have engaging discussion with this presentation. 34 participants are there, but there is no questions. How we can go ahead?
Yes, sir.
I know it's the lunchtime, but lunchtime we get anger to question people, but difficult and thought-provoking questions. There's no question. So we shall move to the next presenters. Thank you, ma'am, for
Thank
giving.
you, sir. Thank you so much.
Welcome. I'm looking for, once again, I'll repeat those who didn't present their paper. Mr. Sharana from the Bangalore University. Rakesh Kumar Sharma. Mr. Imran Akhtar. Mr. Zabiullah Shinwari. Right. Najma Nushad. Ananya. Right. Miss Martina Jacob. Mohammed Subhan. So most of them are absent. Let me see. There are some people who try to join us.
Hello,
Yes.
sir. Am I audible?
Yes. Who is
Sir,
this?
I'm Krishnakant, sir. I would be presenting today. I need some time, sir.
How long time do you need? I have put it in the.
I will be presenting post lunch, sir. I was out right now.
So there is a technical issue. We cannot go for the post lunch because now some people are absent. We either we have to leave or you can present your paper because since it is a live, we cannot postpone. If you can present, you may proceed.
Okay, sir. Can I have 10 minutes time, sir?
10 minutes. Okay, let me see. Is there any other presenters? We have exhaustive list of presenters who have submitted their papers. Yes, we have scheduled the time, but some are absent. Now, since I have given you exhaustive time, like such as 20 minutes per presenters. Now, if 2 is absent, means 40 minutes is a difference. Of course, it creates disparity. Let me try Miss Anna Bashir. No. Rakesh Kumar. Mr. Muhammad Imran Ali. Right. Miss Najma Nushad. Okay. Kuritika. Martin Jacob. So none of them are present here. I think it would be good that we close because today is a Sunday. We shall go ahead. Do you have any question? Is there any issue to be discussed among the audience, or do you have any concern? Or do you have any issue to either pose us, we answer you, or do you have from the paper presenters, or do you have any feedback? Okay, before we go ahead, I would love to inform you that we have shared the Google form. You need to fill up that. If you don't fill up the form, what happens? Then tomorrow you claim that, okay, we have participated, you have not given us certificate. So it would be difficult for us to go ahead. And we don't understand exactly who is, sir. So we don't understand. Yes. There's a question. Yes, you can ask your question, please.
Good evening. My name is
Yes,
Jimmy.
good evening. Yes, good evening.
I had asked an earlier question on the chat box that what measures can be taken to ensure that AI algorithms used in military context are free from bias, hacking, and cybersecurity is aligned with ethical principles.
Does your question concern to any paper presenters, or your question is to the organizer?
I cannot specifically point the specific presenter, but they had presented on the roadmap on AI.
Right. I would love to see you, sir. Could you show your face so that we can have a good interaction with each other? Could you turn on your camera? I would love to bring you to the stage with your question so that it can make more meaningful discussion.
Am I visible?
You're not visible. Yes, now you will be visible. I think you need to turn up a little your camera. Right. Mr. Jimmy? See, if you look to the principle of humanitarian law, if you see the...
Am I visible to the camera?
Yes. Yeah, very much. So if you see, to discuss the issue of militarization and international humanitarian law, we have 2 issues to be discussed. One is the Rome Statute. Nowhere you can get in the Rome Statute a particular answer concerning this issue. And the another one, which we rely on the principle, which is which all the military commanders and the countries establishes that take the precedent of that Geneva Convention 1949 and additional protocol, protocol 1 particularly. If you check in section 51, article 51, 57 plus 1, it talks about that the civilians should be safeguarded, means protected. They should be spared. But there is no such column to talk about AI or use of AI during military. So to consider this, the question always is there, like the country who develop AI is responsible, or the military who the military commander who deployed, or the machine itself. So to consider this from all angles, if you see in the law of tort, what is we say common law, from that principle, somewhere we say that the person who developed it responsible, the commander who deployed not the machine. So machine does not have any sense or feeling. So we are the one who gave a sense for the machine. So considering that now, this is not the responsibility of a single state, and it is not the work of one state to develop in isolation. So it is a question of collective responsibility. I believe that there should be international cooperation, such as ICRC is working. So not only ICRC, there should be some more institution to get involved and they work together and cooperate together, such as academic institutions, civil society, civil organization need to involve and give awareness. And there should be a center of command for AI regulations, such as like there's a very close nexus between internet regulation and AI regulation. As of now, even now, we don't have a particular organization to regulate internet, which is also facilitates the use of AI or something. Of course, there are some small steps by some of the intermediaries. For example, I just give you example. Today we were creating live stream for this presentation. Our system analyst was not able to create, and that was the cause. That was the reason for delay. When we use the word military, the YouTube was not able to, resolve it and post it online. Do you understand? So this matters are sensitive. So if how this is taken, like for example, for intermediaries such as YouTube or Facebook, if all countries take these matters very seriously and consider ethical consideration and putting all these dilemma, and there will be like international frameworks to regulate, definitely it will be regulated. Otherwise, it would be very difficult. Like I just gave you example, I'm coming from a country that's called Afghanistan, you might be aware of. In Afghanistan, the AI, I may say that not robot, but it was a drone. Usually it was used from the Bagram Air Base. Bagram Air Base is located very much in the heart of Kabul, from where initially Americans were using helicopter to shoot either the Taliban or other groups which they were fighting for. So later on, it was difficult for them to fight with them face to face. So they developed this drone. While they're shooting the drone, there is a question of IHL arise, like the principle of distinction, the principle of precautionary principle, what we discussed. But sadly, American did not use the principle of precaution. When the government of Afghanistan questioned them, like, okay, you killed civilians in that, they were saying that, okay, we are targeted our enemies. We targeted what we were looking for, but that was not, this IHL was not working as we discussed. Theoretically, it is different. Of course, this question is, in reality, it would be very difficult for those places which they have seen war in the practical sense. So now we had, like, I may give you another example. They have shoot a bomb is called the mother of bombs. You might have heard or you might have seen somewhere. That causes so much natural disasters and natural calamity. Of course, it would be for American one bomb, but it is for Afghanistan it causes damages to the earth, to the soil, to the people, to the land, and the consequences for the next generations to come. We developed under the Paris Convention the principle of precautionary principles, that is in terms of environmental protection. But if you touch back, connect to the international humanitarian law, again, Article 57+1 say that civilian must be spared. This is a question to be discussed. So I believe there should be international framework, and that framework should not be a soft law. It should be hard to punish the person who is doing so. I hope that I have answered your question.
You have canvassed my question well. Thank you.
Yes. Is there any question? Either to me or to audience? Okay, meantime, I'm looking forward. Is there any presenters who have joined us? I would love to allow them to present the paper. Otherwise, we will wind up the program for today.
Sir, I would be presenting. Sir. I'm Krishna Kant.
Okay, please start. Is there another question till Mr. Jim? Ms. Jamie, do you have another question? Where did you join from?
So good afternoon, one present here. I might be presenting the paper titled
Yes.
I might be presenting the paper titled Addressing the Challenges of Attributing Responsibility for Wrongful Acts Committed by Autonomous Systems and the Implications for State Accountability under International Law.
You said autonomous system. Do you mean autonomous weapon system or something other than autonomous?
Sir, this title covers the autonomous systems. Like it also covers vehicles, it also covers weapons, it also covers drones.
Right.
It's an
okay.
Yeah.
Autonomous systems. So we could use plural then.
Yes, sir.
Right. Please go ahead.
So looking on to the introduction, you all might be known that autonomous systems are the systems which can operate independently without the intervention of the humans. So from this, for examples, there are few examples that which I have said right now, like vehicles. It includes autonomous weapons, it includes autonomous drones and etc. So from further, it has been classified into three kinds of autonomous systems. It includes fully autonomous, semi-autonomous and supervised autonomous systems. So the fully autonomous, which includes no intervention of human beings, whereas in semi-autonomous, it includes a small portion of human intervention which can guide the semi-autonomous system but cannot intervene into its actions. Whereas in supervised autonomous system, the autonomous systems can be carried out its function on the supervision of the humans. These are the three classifications undergone in autonomous systems. And further, there is a certification standards where it is governed. So right now there is no other legal obligations or legal frameworks has been enacted, which is going to be explained in the following context. From here, there is certain standards given for robotics and other medical devices, which is governed by artificial intelligence systems, which can drive autonomously. So this includes like ISO and IS and IEEE. This type of certification organizations which I have included in my paper. And further, I would be looking on to the international frameworks. So deliberately speaking, that international frameworks is no deliberate international or national domestic legislation has been in place for in case of autonomous systems. This would be a great lacuna in governing the autonomous system, as well as my paper focuses on the wrongful acts committed by the autonomous systems. There is no other punishment implications or the accountability for whom it is being taken for the acts committed by the autonomous systems. So firstly, international regulation and governance. Looking onto the international regulation and governance, UN would be a governing body, but it cannot be address the problems which the autonomous system would be committing in a ethical manner. So due to the lack of codified principles or any other ratification has been in place. Further, looking on to the as I said before, decision making and ethical standards as a great lacuna in autonomous systems. Whereas in European Union, they have addressed this and made their ethical guidelines in their union itself. Whereas in any other autonomous system used by various countries, there is lacuna still in place. Further, standards for safety and security is also a major concern it would be looking for. Whereas international electrotechnical communication and the International Organization for Standardization, as I explained before, certification and standards has been prescribed, though it has not adopted by many of the nations around the world. Looking onto the international study, global partnership on AI, which is said to be GPAI, would be a research platform which can be used for deciding such matters, but still there is a lacuna present for addressing the major concern where mass damage to the society which has been caused by these autonomous systems is still in place. Looking on to the state accountability, the accountability which involves law, technology, ethics, and international relations. In this, there is no explicit legal framework has been present for whom the accountability has been takes place for the wrongful act committed by these autonomous systems. In the international sphere, countries are typically responsible for behaviors of both state agents and organizations within their authority, does not cause harm to the others. But however, the state is not obliged, because the private institution which has been causing this made to happen, where they has formed these autonomous systems, would be a great question which is needed to be addressed. So the accountability still is been a question mark over here. So the challenges which I have been found on doing this paper would be firstly, digital dehumanization would be happen. The autonomous system, the fully autonomous systems which can drive on its own. In this case, the humans' participation would be rapidly declining. In this case, digital dehumanization would be caused. The other concern in this matter would be digital humanization, completely digitally without intervention of human, would cause the which lesser the human participation, and it also mentally and physically would suppress the growth of the humans. Then secondly, algorithmic biases would may happen. For example, the autonomous systems, the person who is intended to happen may cause such algorithm and causes damages or wrongful act, and yet it has been not governed by any international framework, would be in much concern which is being addressed in this paper. Further, the technological relationship would be cause rapid decline and lack of human judgment and understanding. So AI has been less understandable by the large mass of people. In that case, this would be a great challenge for the like humans could deliver its judgment in the ethical manner. And as we discussed above, the accountability would be rapidly no reason. The accountability would be not rely on anybody. How could the machine being punished? It's none of the use, right? So further, in this case of challenges, we would be having some solutions and recommendation to address these wrongful acts committed by the autonomous systems, which includes firstly usage of semi-autonomous and supervised autonomous system would be much effective, which is under the control of the humans, not fully taken their autonomy. Secondly, international law should be mandatorily being made, and further domestic laws for their nations would also be made for addressing these wrongful acts committed by these autonomous systems. And the third recommendation that I would be preferring is accountability of state shall be found for different category. Already there has been a great question that who would be taken the accountability. In that case, express rules or regulation criteria has to be made for such accountability, either the individual, the state, or the private organization which is going to be taken the responsibility for the wrongful act committed by them. Further, the self-driven cars which has been fully driving in their autonomy would make have a reason to cause an accidents or any damages. For that case, like semi-autonomous, it is to be happen in semi-autonomous way. They should be provided with the steering and control levers, where human has the control over the systems. And global ethical framework has to be made for the to direct the development of autonomous technology. And further, autonomous vehicles must undergo extensive testing for real world obstacles such as road conditions and crash scenarios, which is being rapidly in growth globally. And further, these autonomous system may have probability to cyber attacks, can target the autonomous system. For this case, the standards and security protocols has also to be published. And further, global framework establishing uniform standards for data collection, storage, and could aid pressure people's preserving people's privacy. It is also to be ensured. The privacy concern is different in different countries. So for in the reason of autonomous systems, it should be governed by a legal framework. And further, the environmental concerns also should be overlooked. The environmental concerns which causes damages to the society should be eradicated. The autonomous system which improves the sustainability of the environment shall be preferred in this usage of case. From this paper, I'm moving on to the conclusion part. The conclusion would be there is a need for addressing the wrongful acts committed by the autonomous system. Yet, from the point, there has been no explicit legal framework for no other legal obligations, or even national domestic laws has also not been in place. In the growing era of technology, artificial intelligence and autonomous systems would be in a rapid growth. So it is needed to be addressed, and explicit laws should be made in this concern. That's all the paper discusses about. Thank you, one and all.
Yeah, thank you so much. Who is your co-author? Or you are the co-author?
Sir, I'm not audible, sorry.
Okay, can you tell me who is your co-author?
Sir, I'm the only author.
What is your good name?
Krishnakant.
Okay, right. Did you get my feedback?
Sir, no, sir. Please, yes. Please.
You didn't receive my email.
Can I say my email, sir? What?
Okay. Did you receive my email?
Yes, sir. I received your email.
Right. Right. So we're looking for the next presenters, Ananya. Okay, Martina, did you join? Once again, Mr. Muhammad Imran Ali, Qaid-e-Azam Law College, Pakistan. Okay. Rakesh Kumar, Miss Kritika. Right, Mr. Subhan. So all are absent. This is my third or fourth time to call their name. Right, we come to the conclusion of today's discussion. As a part of rituals and ceremony, I would like to deliver word of thanks. Good afternoon to all of you, and it is both honor and privilege for me to deliver word of thanks. It means to be grateful for you. And we come to the end of this program, and this was, of course, a thought-provoking debate since yesterday, and we have discussed thoroughly around intricacies of military AI and humanitarian law. Even further, we have highlighted the issue of precautionary principles that was highlighted much deeper by our esteemed speakers, and particularly today we have discussed on the legal implication by our esteemed presenters. And I would love to stand here on behalf of my organizers, particularly Dr. Kenneth from the Nairobi Law School, University of Nairobi, Professor Antonio Giorgi, and who is the professor and the doctorate program at the Unified University Brazil, Dr. N. Wanishri, Principal JSS Law College and Institute of Legal and Policy Research. And I would love to be grateful for all the esteemed speakers, paper presenters, and participants who have made this event possible. We would fail to acknowledge your participation and your paper presentation. Whatever we have done, if today it is a successful or we think that this program is completed, it is credit goes to all of you that you have taken part. I would love to highlight a special thanks to Professor Dr. Shirina Waslo, professor at in UGS Kolkata, Dr. Kenneth, who was a speaker, and Professor Antonio Georgi, who woke up early morning and joined us, Miss Anastasia Jorel from the Ukraine, and Dr. Elizabeth Hofer-Pippen from Germany. She promised to join us due to her health condition. She was not able to. And Mr. Raul from Netherlands, and of course, Professor Maruti and Mr. Solomon Gerima, who were the special guests for us and who spoke on the topic. And we have discussed around the critical discussion about the challenges, ethical consideration, and intricacies of military AI and IHL. So, and the paper presenters, your work was paving a way for this crucial conversation, which definitely shares your perspectives and around this rapid evolving field. So I would love to extend our sincere thanks to all of you and each one of the speakers and participants who have made this program successful. And I would love to be grateful to my technical team, particularly Mr. Madhu Kumar and Mr. Akshay Chakraborty, Faculty of GSS Law College, who has coordinated this program too. And we have facilitated this outstanding success. And starting from the planning to outreaching to the technical and coordination until the end of the program. Thank you so much for joining us. If you have any question, please, you can address us. Is there any question? Concerning your participation and certification, please fill the form. We would love to issue your certificate before a week. If not possible, we try from now to give you within 2-3 days, but it does not extend to a week. About your paper has been sent to Nairobi. They are making review and corrections. After that, you will get your paper presented. I mean, published. Of course, that is subject to, again, the plagiarism check and edition and feedbacks what we get from the peer review team. Is there any question? So I see no question. Thank you. We shall wind up the program. Thank you, one and all. Thank you so much.